Leave to mention item number 31. This matter assigned before your lordship.
Yes.
My lord, today may not be taken up. My lord, this matter interim order expire tomorrow, my lord.
Item 31, interim order.
Expire tomorrow, my lord.
You are for the petitioner.
Yes, my lord.
You are for?
No,
So, intimate the other side. Tomorrow I'll take it up on mentioning. If it cannot be taken up tomorrow, I'll extend the interim order. Intimate the other side.
may I be permitted to mention these 3 stay applications? New application, already execution case has been
Yes,
filed and they are
yes,
proceeding
give it.
with this case. If this is not enlisted, my lord, the execution will take place.
Yes.
I have annexed a copy of mail from my client that I have given annexed.
May I have your lordship's kind leave to mention a matter for inclusion? Your lordship last heard this matter on 25th of March 2025.
Probably you ascertained whether it is a CAV matter or it was fixed for further hearing. Okay.
Fixed for further hearing, my
So
lord.
if it is fixed for further hearing and there is a change of determination, I cannot hear the matter. You have to get it listed before the regular bench.
Your lordship, grateful.
Yes, not today. Not today.
Lordship, I am appearing on behalf of the petition and praying for a short passover. Led by Mr. Bolala Shaw is engaged in code number 551.
Okay. Pass over.
Grateful, Lordship.
Lordship, item number 34 and for the petition.
I've made it not today.
At 36 and 37, Mr. Purimal Kumar Padi is appearing on behalf of the insurance company. I am praying not today on this health ground.
Not today.
If you bless, my lord.
Here I am for the appellant, my lord.
Yes.
Stay has already been granted till disposal of the appeal, and condemnation of delay is also been delay has also been condoned.
So the matter has to be heard out.
Matter has
Books
to be heard out.
filed.
Yes.
Yes, record an order.
He was the other side was directed to prepare paper book, but paper book is not complete, I think.
Paper books is not yet filed.
He has probably filed, I think, but it is not complete. No index, etc. is there.
Anyway, then let it be not today.
Come on, let the hearing be fixed.
Because I don't know if the paper books are not filed, how can the hearing take place?
Probably he has filed, my lord. If you go through the record. Huh?
So let a date be fixed in his presence. Okay, let me ascertain.
Let it be taken on Monday.
Okay, not this week.
My lord, I'm praying for a very short passover. Very short passover.
Okay, pass over.
What 41, my lord, I am appealing for the appeal and claimant, my lord. My lord, in this appeal, my lord, 3 points involved. Number 1, my lord.
What is this application for?
Application for condonation of delay, my lord. 169 days delay, lordship.
Let me take up this. Let me see. Yes, record an order. Learned advocates for the parties are present. The application for condonation of delay is taken up for consideration. Heard learned advocates produce the petition filed. Upon hearing the learned advocates and upon considering the application filed, this court is of the view that the appellant has furnished sufficient grounds for condoning the delay. Thus, delay in filing this appeal is condoned and the appeal is admitted.
My lord, informal paper book, my lord.
Yes. The paper books filed
Hmm.
be kept with the record, copy be served.
My lord, it is only on the point of future prospect and my lord interest, my lord. Your lordship will kindly fix it up any day. It will take 5 minutes of my lord's time.
Yes, let this matter appear for hearing.
Short-
দেখুন কবে আছে?
Short dates, my lord.
আবার
Three-
বলে দিয়েছি আবার।
There are different matters fixed.
Yes, my lord. My lord, since it would not take long, my lord, is only on quantum on dot point, my lord.
Let me see my diary.
Lordship.
30 না 31? Yes, the matter can be sent to Lok Adalat also.
No, my lord.
Yes, can it be settled?
My lord,
It's better, you see, I am unable to fix it before this last week of March. It's better you exhaust.
My lord, fix it up in the last week of March, my lord, you will get it disposed of.
No, better you exhaust your remedy there.
My lord, in Lok Adalat, my lord, settlement is to be reached, my lord, they would not be coming down from the quantum what my lord is deciding in this court. Suppose my lord grants, my lord, then 100 rupees in Lok Adalat, my lord, insurance company, my lord, requests them to settle for 90. That, my lord, 10 rupees they won't lose, my lord. That is why, my lord, it is not going to be settled.
But you
in Lok
take
Adalat.
your chance.
No,
You
my lord.
convince your client. Why? If the matter can be settled.
No,
My lord, it will hardly take 5 minutes of my lord's time.
Okay,
The
let
points
this
are
matter
decided.
appear on কবে আছে দেখুন তো? কবে ফাঁকা আছে?
হ্যাঁ।
30, 31 না কবে?
দুটো সময়
হ্যাঁ, হ্যাঁ,
হ্যাঁ করে নেবো।
হ্যাঁ, করে নেবো।
Okay, 2 p.m. Okay, so let it be taken up at 2 p.m.
Yes,
লর্ডশিপ
my lord.
ঠিক আছে, থ্যাংক ইউ,
Okay, my lord.
থ্যাংক ইউ।
তাহলে ওর অর্ডারটা লেখার দরকার নেই তাহলে।
ওয়ার্কআউট করো তাড়াতাড়ি। না না হয়ে যাবে, ছোট্ট হ্যাঁ 5 মিনিটে না, 5 মিনিটে না, চিন্তা করবেন। My lord, 42 is the insurance appeal, is appearing for the first time. My lord, there is a delay in this case of 64 days. I was praying for, my lord, the interim stay. May I file my affidavit of service, my lord? 42, huh? 42. No, 42, no, I'm sorry, my lord, that is not 42. My lord, 42, I'm for the appellant, my lord, it has not come up at my instance. ওটা নিচেরটা আছে।
42 year for the appellant.
I'm for the appellant, but it has not come up at my instance, my lord. I do not.
So can 2 is whose application?
Can 2, my lord, is application for condonation, my lord. Application for withdrawal, not filed by me. One, my lord, Mukund Sarkar is there, my lord, he has
Application for
mentioned this.
withdrawal.
Perhaps for
Okay,
withdrawal.
then not today.
Not today. এই কোথায় থেকে নিয়ে আসে মামলাগুলো? My lord, 43 is the appeal of insurance, my lord, the appearing for the first time. Lord, my affidavit is before your lordship. But I was begging, my lord, to delay to
Can
be,
2 is your application?
my lord, delay for condonation, my lord, application for condonation of delay.
Yes, record an order. Learned advocate for the appellant is present. The
Huh.
none appears for the respondents in spite of service of notice.
Can one is delay?
The application for condonation of delay is taken up for consideration. Heard learned advocate for the appellant produced the petition filed. Upon hearing the learned advocate and upon perusing the petition filed, this court is of the view that the appellant has furnished sufficient grounds for condoning the delay. Thus, delay in filing this application, filing this appeal is condoned and the appeal is admitted. Stopped. Then can 2,
Can 2 is my application for stay, my lord.
the application for stay being can 2 of 2025 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 24th day of April 2025, passed by learned additional district judge, second fast track court, Lalbagh, Murshidabad, in MSC case number 10 of 2021 for a period of 5 weeks. Stopped. The appellant shall take steps to, the appellant shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Yes, the Registrar General High Court Calcutta is requested to invest the sum deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Extremely grateful to your lordship. 44, my lord, I appear for the appellant insurance company. Appearing for
I appear for the respondent number 1 and 2.
there is a delay of 80 days, my lord.
Yes.
I have deposited the statutory amount. Memo no. Not আমার কাছে।
Yes, record an order. Learned advocate for the appellant and learned advocate for respondent number 1.
1 and 2.
Respondent number 1 and 2 are present. Heard.
Respondent number 3, my lord, did not contest.
The application for condonation of delay being Can 2 of 2026 is taken up for consideration. Heard learned advocates peruse the petition filed. Upon hearing the learned advocates and upon perusing the petition, this court is of the view that sufficient ground is furnished for condoning the delay. Thus, delay in preferring this appeal is condoned and the delay is admitted. Can 2 of 2026 stands disposed. Yes, the application for stay being Can 1 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 17/6/2025 passed by learned additional district judge, second court, Shuri, Birbhum, in MSC case number 45 of 2013 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of the appeal. Liberty to mention. Yes, trial court records have come.
No.
No, my
Appearing for
lord.
only one thing. Only one thing. The entire amount with interest raise the statutory amount. That my lord has not.
That is implied. Amount the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount.
My lord,
আর একটা তার তলায় লিখে দেবেন, the Registrar General High Court Calcutta is requested to invest the amount deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Yes.
my lord, one thing, my lord, this appeal is only point of quantum, my lord.
Yes.
Because, my lord, and another thing, my lord, pay and recover. My lord, it cannot.
Yes, paper book filed.
No.
The paper book, my client will file within 4 weeks. My lord, kindly.
Yes. The trial court records we call for.
Okay. Not required.
The trial court records are dispensed with for the time being. The paper books we filed, but you do one thing. If the vehicle owner has filed a written statement.
No. Vehicle owner did not.
No. Sometimes you see vehicle owner files written statement, but that written statement is not incorporated.
My lord, if the vehicle owner, my lord, file the written statement, I shall incorporate.
Yes. Let the informal paper books be filed within 4 weeks. Liberty to mention.
My lord, one thing, my lord, kindly fix the date, my lord.
No, you mentioned after 4 weeks.
My lord, kindly fix the date, my lord. It is a matter of 5 minutes, my lord.
Okay, I shall 5 minutes, 10 minutes.
Kindly, my lord.
Okay, liberty to mention after 4 weeks.
I appear
And
for.
my lord, deposit made by with the insurance company, my lord, within 4 weeks.
Yes, that I have.
That is there.
That insurance company will do. I appear for the appellant insurance company. Appearing for the first time, there is a delay of 17 days. I have served the stay application as well as the section 5, my lord.
Delay of
17 days.
Yes, record an order. Learned advocate for the appellant insurance company is present. None appears for the respondents in spite of service of notice. The application for condonation of delay being Can 2 of 2026 is taken up for consideration. Heard learned advocate for the appellant peruse the petition filed. Upon hearing the learned advocate and upon perusing the petition filed, this court is of the view that the appellant has furnished sufficient grounds for condoning the delay. Thus, delay in filing this appeal is condoned. The appeal is admitted. Can 1 of 2026 stands disposed. Stop. The application for stay being Can 2 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 26/8/2025, passed by the learned additional district judge, First Track First Court, Barakpur, North 24 Parganas, in MSC case number 65 of 2016 for a period of 5 weeks. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount, within 5 weeks. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General High Court, Calcutta, is requested to invest the sum deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
I appear for the appellant insurance company.
Yes,
I appear for the appellant insurance company. Appearing for first time, there is no delay.
this one, yes. Yes, learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 28/10/2025, passed by the learned additional district judge, First Court, Paschim Medinipur, in MSC case number 180 of 2020 for a period of 5 weeks. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General High Court, Calcutta, is requested to invest the amount deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Only one thing, can you direct me to serve the copy of the application upon the claimant respondent?
So you do the needful in the
Fine,
meantime.
fine.
Okay, do the
Fine.
needful in the meantime and then mention.
Fine. Deeply open.
In this matter, I am for the claimant respondent cross objector. But I have filed one CAN application, my lord, for incorporating one additional ground in the cross objection, my lord. One amount has been unnecessarily deducted. That was deposited by the employer, not in connection with any motor accident claim case. It is not a workman's compensation. That amount has been deducted, my lord. That ground I want to incorporate. What will be the fate, my lord, that will be decided by your lordship in the final hearing. But I want to that
No, what is the ground?
ground is, my lord. In the schedule I have mentioned, page number 6 of my CAN application. In ground number 4A, for that the learned tribunal erred in law and in fact by deducting rupees 8,44,680 from the total awarded amount, which was neither paid by the owner of the offending vehicle nor paid by the insurer of the offending vehicle, and which is not a part of compensation.
Yes, what is your instruction on this application?
My lord, let it be incorporated in the cross objection, but it will be heard at the time of hearing of the appeal. My lord.
Yes,
But for
recorded
incorporation, I do not object. My lord.
Learned advocate for the parties are present. This application, Can 1 of 2026 is taken up for consideration. The appellant claimant in COT 124 of 2025 has prayed for incorporating separate ground, being ground 5A or 4A,
4A, my lord.
but you have stated 5A here.
In the
You see the schedule, you
schedule,
have
my
stated
lord,
5A.
5
It should be 5A.
will be, my lord, 4A.
Okay, make necessary rectification
My lord, 4A, my lord, 4A.
as 4A.
4A.
Upon hearing the learned advocates, the appellant is permitted to incorporate this ground. However, it shall be decided at the time of final hearing of the appeal. The application stands disposed. Necessary rectification be made with regard to the mistake serial number of the ground.
My lord,
4A, my
my
lord,
lord,
4A.
since the grounds have been added, my lord, will there be a need to, my lord, prepare supplementary paper book, my lord? Because the paper book, what is there in this, my lord, the cross objection is not containing, my lord, this additional
Let
ground.
a supplementary paper books be filed incorporating the new grounds.
Supplementary paper book I will file.
Yes.
By the
Liberty
claimants,
to mention.
my lord, by the claimants.
By the claim.
By the claimants.
By the claimants, respondent number 1.
My lord, respondent number 1.
1. Liberty to mention.
Grateful to your lordship, my lord.
49 lordship, I am for the appellant. Lordship, here lordship, I have filed one application for expressly hearing along with lordship, can you direct me soft copy upon the respondent, and lordship kindly please to call for the record if not yet called for.
Trial court records.
Trial court record.
And paper books have not yet been
Not
filed.
yet been filed, lordship kindly give it.
Yes, record and order.
Record, call for this.
Who is appearing for the insurance company?
No one is appearing, lordship. Rather, I didn't serve any copy upon the.
Yes,
I
learned
confirm.
advocates for the appellant is present. Let learned advocate is requested to cause service of this application Can 1.
Yes, Lord. Upon the only insurance company, owner did not contest.
Okay. Copy of the application Can 1 of 2026 along with the memo of appeal upon the respondents. The trial court records be called for and the paper books be filed. The trial court's records be called for at the special messenger cost of the appellant. The paper books be filed on arrival of the trial court records. Liberty to mention after 4 weeks.
So the cost will be deposited by a week or whatever time.
The special messenger cost be deposited within 1 week.
Okay. Lordship, responding.
My lord, I am for the respondent insurer in this case.
I am for the claimant's appellant. One section 5 application was filed lordship.
Can 1.
Delay lordship 846 days delay. And lordship, we have explained the
140.
grounds. Para number 6 to para number 12 lordship.
কন্ডোনেশনটা সার্ভিস করো নাকি দেখি প্যারাটি আমরা কি আছে
এটা ছোট ম্যাটার শর্ট ম্যাটার কিন্তু এটা ওই লোক আদালতে করে নেবো এই হলে
ফাইল হারিয়ে দিয়েছি
কপি সার্ভিস হ্যাঁ এভিডেন্স সার্ভিস দিয়ে দিলাম তো
না এই সেকশন 5 আপনাকে দেওয়া হয়
Yes, Mr. Singh, what?
My lord, abnormal delay, my lord. My lord, an award of 25 lakhs plus has been passed, awarded, and my lord paid.
So he is aggrieved by that
My lord,
Anyway, let the delay be condoned, let it go to Lok Adalat. Thereafter, I shall
Lordship,
speak.
local lordship, some grounds are here are some grounds lordship which cannot be settled by local law.
If the settlement fails, I'll hear it at the end of March. Yes, record and order. Learned advocates for the parties are present. Heard learned advocates on the application for condonation of delay. Although the delay in making this application, preferring this appeal is how many days?
846.
846
46 days. Lordship.
846 days, but the appellant has furnished sufficient grounds for condonation of delay regarding file misplaced by the former advocate and thereafter time taken to apply for the certified copy. After
Milord.
hearing the learned advocates and considering the grounds, this court is of the view that in the interest of justice, the delay should be condoned. Thus, I condone the delay in preferring this appeal. Stop. The appeal is admitted. As the respondent number insurance company is represented, for formal notice upon the respondent number 1 is dispensed with. The matter be sent to the National Lok Adalat to be held in the month of March 2026. Fix. Okay, 25/3/2026 for report of the Lok Adalat.
My lord, one indulgence, my lord, since delay is inordinate, lordship will record my formal objection to that, my lord, because otherwise, my lord,
Upon
a
hearing
little
the
too much,
learned
my lord.
advocates and considering the objection raised.
Lordship. God bless your lordship.
Much.
51, my lord, I am appearing on behalf of the appellant insurance company. I have deposited 25,000. This is the copy of the challan. There is no delay in the matter.
Record. Yes, record and order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 27th day of November 2025, passed by learned additional district judge, first track, second court Alipur, South 24 Parganas, in MAC case number 910 of 2015 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within 5 weeks. Stop. In the event the entire amount is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General High Court, Calcutta, is requested to invest the amount deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Grateful, my lord.
Lordship, I am for the petitioner, my lord. The Section 5 application, my lord.
My lord, I have been instructed my client to appear before your lordship.
You are representing which respondents?
1 and 3, but the Vokalatnama I could not file, my lord. It is not the
File it in course of the day or tomorrow.
It is not the latest, my lord. It has been, my lord, the amended provision, my lord. It should be my congress paper and that should be filed, my lord.
I'm granting you the liberty. You have the copy of the application under
Yes.
Section 5.
Yes, my lord.
Yes, give the records.
More than, my lord,
67 days delay.
67 days delay. Yes, what do you say?
my lord, inordinate delay, my lord. If your lordship, my lord.
It can be condoned, my lord.
And 2 court they have not succeeded.
2016, my lord. And
Yes, record and order. Learned advocate for the appellant petitioner and learned advocate representing respondent number
1 and 3.
1 and 3 are present. Or 2 is not represented.
My lord, till now, my lord, I have not.
Have you served all the respondents?
Lordship, I have, sir, but from this affidavit of service showing that bag has not dispatched, madam. All the items are not delivered, madam. Only,
And there are another others responded also.
but since long,
No, it was delivered, all the respondents.
1 and 3 is showing that they have.
That's why I am appearing 1 and 3.
And 2, you don't know. Then 4, 5,
4, 5.
all were plaintiffs opposite parties.
Yes, my lord. Long back served, my lord.
No, no. Is it delivered to the addressee?
Not showing. Bag dispatched only.
Then that will create some difficulty.
Then, my lord, may I serve again and come back? My lord?
Press service is
Yes, learned advocates for the appellant, petitioner and learned advocate for respondent number 1 and 3 are present. As service upon respondent number 2, 4, 5,
2, 4, 5.
and 6.
No, 6.
6. 6 you serve the GP?
Yes, yes. State.
2, 4, 5 and 6 is not complete. Learned advocate is requested to call service upon the respondent number 2, 4, 5 and the learned government pleader, State of West Bengal. Such service be effected within 1 week. Let this matter appear under the heading application on 12/3/2026. Learned advocate appearing for the respondent number 1 and 3 is permitted to file the Vokalatnama
In the meantime.
in the meantime.
Get.
Evidence service.
My lord, in this matter, I beg to appear on behalf of the respondent number 1, my lord. On the
He
last.
was for the otherwise, my lord, others have been served. My learned friend is appearing. The section 5 and for leave to prefer an appeal.
I intend to use an affidavit with regard to section 5 and all this. There was a leave granted by your lordship. I am seeking extension of the time to file the opposition, lord.
No, question is, you see, the application for condonation of delay was taken up by this court or some other way?
No, by your lordship.
By your lordship.
Section
By your
5.
lordship, my lord.
Then with regard to the grant of leave, that is also to be taken.
My lord. Leave to file appeal.
So you want to file affidavit in opposition to section 5?
Both.
So it is why it is not filed in the
My
meantime.
lord, the client was very much ill, my lord. I could not contact him. But by this,
For my learned friend takes section 5. My lord, there is a question which you can to consider by your lordship also, whether section 5 leave to appeal, when unless until leave is granted, whether section 5 applicable or not. That is the only one thing. If it is applicable, then what will be the consequences or the
Leave to-
because I am not a party to that proceedings.
No, question is, an appeal has to be preferred within the period of limitation.
Limitation.
Even if a person who is not a party, if he has some knowledge about that,
Yes, my lord.
he can also file it within the period.
Yes, my lord. That is precisely.
Whatever it is a formal in nature.
That is what.
In the event if he intends to file, let him file.
As your lordship
My lord.
pleases, my lord. But because they have already, though I have been position, they have initiated proceedings for exit. Let them.
Those are on merits, my lord.
No. That is why, my lord, some.
Learned advocates for the parties are present. Learned advocate for respondent, all the respondents.
No, one.
He is the
I'm the one, my lord.
original respondent who is
Principal respondent.
principal respondent.
Others have been served.
Yes. They earlier occasion they appeared also.
Yes. Learned. Mr. Shamanto, learned advocate for the respondent number 1, prays time to file affidavit in opposition. Such prayer is allowed. Let affidavit in opposition be filed on or before 13th March 2026. Reply if any
7 days.
before on or before 20th March 2026. Let this matter appear on 23/3/2026.
Let the file opposition investor both leave to, otherwise if I will use, because otherwise again to the section 5 and the leave to appeal.
2020. Yes, enough time you are getting.
That is why.
23/3/2026 under the heading application.
My lord has
In the
indicated.
meantime, for any execution proceeding.
Yes, they have initiated the execution proceedings.
As the matter is sub judice before this court, there shall be stay of all further execution proceedings, if any, for a period of 6 weeks.
Grateful to Lordship.
Hmm.
Fifty-five to.
No.
55 I beg to appear on the appellant petition. There is a direction to serve copy upon the respondent. I have served this the affidavit.
Section 5.
Section 5, only 50 this delay occurred to file because my.
You are appearing for?
So respondents.
All the respondents?
Yes. But your lordship, the learned advocate who is appearing for the matter couldn't come to court today due to personal grounds. So that's why I'm praying for time, your lordship.
Section 5 application.
53 days delay.
Anyway, I'll take it up in the next week. Is there any execution proceedings pending before the trial court?
Trial court? Well, I have no knowledge about whether.
Anyway, I'm just making it not this week. It will retain its position.
Formal application, well, only 53 days delays. Execution nahi to?
Anyway, then only not this week. It will retain its position.
Gratefully, lordship.
Affidavit service will be kept. Order হচ্ছে না তাহলে ওটা ফেরত
You take it back on the next day.
Gratefully, lordship.
And I'm for the appellant, lordship. Lordship, it is a limitation application, lordship. There is 14 days delay, lordship.
Service is complete about
Lordship, that is I have sent twice, lordship. There is a typographical mistake in the memo of appeal in the address, but I have sent in the correct address, lordship. It is twice I have sent.
How many respondents are there?
Only one, lordship.
Only one respondent?
One respondent.
So it has returned?
Yes, lordship.
What is the...
Lordship, typographical mistake is Motindro and Mohendra. I have seen the correct address also. Correct address, lordship.
So let me see the envelope.
There. দেখুন দুটো দিন আমাকে দুটো আছে That is the correct one. Correct address. Mohendra Mukherjee.
No such person. Okay, then you take necessary steps for fresh service.
Lordship, I already twice I have served, lordship. The same.
Twice it has returned?
Yes, lordship.
What is the other?
It is first time and that is the second time.
Let me see. What was the earlier remark? No such person. Same thing.
Same address, same remark, lordship.
Any execution case pending?
Yes, lordship. That is there.
Oh, execution case is initiated. You are the defendant in the trial court.
Yes, lordship. First court I own. They filed the suit for recovery of cash position, lordship. They lost, and thereafter they filed the appeal. And
then you do one thing. I am granting you the liberty to serve the respondent and the lawyer of the trial court who is appearing before the executing court. That liberty I'm granting you. Yes, record an order. Learned advocates for the appellant petitioner is present. It appears from record that twice service was caused upon the respondent, but the envelope has returned with the remark,
Lordship, I'm not
such
sure.
person,
I'm not sure whether execution process is going on or not, Lordship.
no such person is residing. Or you don't know whether execution case is going on or not.
No, Lordship. Lordship, let the direction be given. I will try.
Okay. Learned advocates for the appellant is requested to cause service once again upon the respondent at the address, as well as the learned advocate who appeared before the learned trial court or before the learned appellate court. Stop. Execution proceedings, if any, shall remain stayed for a period of 3 weeks from date. Let this matter appear on 16/3/2026.
Grateful, Lordship. No.
Sir, I am for the appellant, my lord.
I
My
am
application
respondent
for stay, the matter was mentioned upon notice, but after that there is a long gap. So, my lord, if your lordship, one of the respondent is appearing, my lord, Mr.
I
Nonigopal
am not the
Chakraborty.
principal respondent,
Yes.
I am the municipality.
Mr. Nonigopal Chakraborty is the principal respondent, my lord.
Let me see.
Appeal has been admitted, my lord, 9th September.
16
June.
16 June of 2020.
16 June it was admitted. Stay was granted. Affidavit direction was filed. No affidavit has been filed by the respondent. Can't stay.
Stay. Can one.
So plaintiff respondent is not before this court.
Plaintiff respondent is not. We have given notice before mentioning, but there's a gap.
But service is complete.
Service is complete.
Plaintiff respondent has entered appearance.
Entered appearance, my lord. At the time of admission hearing, he was present. But
so affidavit in opposition is to be filed to the application
filed by
for
them,
stay.
yes, for stay. It has been admitted on the point of made. We have taken the point of, my lord, jurisdiction of the locus of the plaintiff, my lord, to
Okay,
file the
identity order of stay will expire when?
No, it is till disposal. Till disposal.
Okay, then means it is continuing.
Continuing. I can give a notice, and if your lordship takes up in the next week, after 1 week, my lord, I'll
Yes, record an order. Learned advocate for the appellants, petitioners, and learned advocate for respondent, pro forma respondent number 2 are present. None appears for the plaintiff respondent number 1. However, in the interest of justice, the matter stands adjourned till 10/3/2026. Let this matter appear on 10/3/2026 under the same heading. Learned advocate for the appellant is requested to serve one more notice upon learned advocate for the plaintiff respondent number 1. Affidavit in opposition filed in the meantime.
oblige.
Well, item number 58, my lord, this is an innocuous application, my lord. At the time of order 41, my lord, the other side.
And for the legal aids.
On the other side has mentioned before the court that the respondent one is dead.
Yes.
And he has disclosed the names of the legal heirs, my lord. We immediately file an application, my lord. This application has to be allowed so that the heirs of
Yes,
the
yes, Lord, we do not have any objection to that.
respondent should be incorporated. Then the matter
Which
should-
respondent died?
Only respondent one, my lord. The different one contested and
Sole
other.
respondent.
No, well, other respondents were there, my lord. They are not contested. It is
No, anyway, so you have filed this application to record the death of respondent number
number
1.
one, my lord. Your lordship will kindly seize the name, my lord. The heirs has been stated on behalf of the respondent one.
yes.
They are the legal heirs. If your lordship kindly comes to page 11, they have disclosed that the Savitri has died, leaving a one son, one daughter. And they are
Scan 2.
Scan 2, my lord. Your lordship will find, my lord, that is Scan 2. Scan 2 application, my lord, and we have stated in the application that the heirs are Phalaram and Lokila. Look, they should be incorporated in
It
the
was before the division bench.
division bench.
Okay, so it was sent to single bench.
Single, because at the time of the admission, my lord, the other side took a point. In the meantime, the respondent one is dead. Thereafter, I took out this application on the disclosure of the heirs of the order.
Yes, record an order.
Can
Learned advocates for the appellant and learned advocates for heirs of the
Yes, my lord. Respondent number one.
heirs
Legal heirs.
representing respondent number 1, Lotika Lohar, since deceased, are present. Our learned advocates peruse the petition filed. The appellant has prayed for recording the death of the sole respondent, Lotika Lohar, and substituting legal heirs.
Not the sole respondent, the respondent number 1.
The respondent number 1.
Respondent number one.
And the heirs has been depicted in paragraph number 10.
As stated in
Paragraph 10.
of this application. Upon hearing the learned advocates and upon perusing the petition, this application stands allowed. Let the name Lotika Lohar be deleted from the cause title and names of her legal heirs as mentioned in paragraph 10 of this application be incorporated in her place and state. The amendments be carried out within a period of 2 weeks. Liberty to mention.
Department should record the names and send it to the office.
Yes, the amendment means by the department. Yes, also.
59, I am for the appellant. So this is section 5 59. Section 5 application, my lord. We served and lord moved on the previous day. They were not present. The lordship directed us not to serve the learned advocate. We have given a notice.
Appearing in the trial court. Yes.
It has been
Yes, give me the
by
application.
post. He did not take up the physical copy. We have given by post.
এটা আমার অফিস কপি
Can 2 or can 3?
আগে রিভিউ
Can 1 or can 3? 2 হবে না. This lord appeal has not been admitted yet, not
No.
section 5 stage.
1 আর 3 দুটা তো স্টে 1 আর 3 টাই সার্ভ করেছি পুরো নোটা তো আগেই ছিল
Can 1 is not for condonation and the can 3 lord for accepting deficit court fee, because there was a report that deficit court fee is there. We have deposited that, but for that I have to formally make an application lord for this delay also. Can 3 is not deficit court fee.
নোবারই এক্সপ্লেনেশনটা
Can 3 I have explained everything, lord.
Can 3 is for
Can 3 is
deposit the deficit court fees.
Yes, after condoning delay, because of deficit court fee there will be a delay. To accept it after condoning delay, and I have explained the entire delay in paragraph 8.
Can 3 is to be taken up for consideration.
Fine. It explains the entire delay.
Yes.
554.
ওয়ানটাও তো অফিসিয়ালি ডিসক্লোজ করতে হবে তাই তো সেকশন 5 সেকশন 5 এর কপি আছে রাশিয়ার কাছে নেই থাকতে তো ক্যান কপি আনো এক্সট্রা কপি আছে দিয়েছি ক্যান ওয়ানের যদি বলে
Can I coordinate against hours? Like 32.
লজিক্যাল একটা লজিক্যাল এখানে ছিল এটা কোন ওইটাই ওই যে ডিলিট দেবো একটা ডিলিট আছে এই যে লজিক্যাল অর্ডারে
Yes, record an order. Learned advocates for the appellant is present. None appears for the respondents, all the respondents, in spite of service of notice. Let the affidavit of service filed be kept with the record. The application for
Well, it was filed on the last day. Affidavit of service was filed on the last day. This is not the
the
service upon the
affidavit of
advocate.
service
Was filed.
causing service upon the trial court advocate be kept with the record.
Service to করিস
The application for condonation of delay is taken up for consideration. Stop. The case of the appellant petitioner is this. Pursuant to the disposal of appeal by the first appellate court, the appellant was seriously ill and was unable to contact his learned advocate. However, after August 2024, when he recovered partially, he contacted the clerk of the learned advocate appearing before the appellate court to obtain certified copy. He was informed that the court was closed for vacation and he will get the copy after reopening of the court. In spite of repeated attempts till January 2025, when the certified copy was not obtained, the appellant petitioner contacted the learned advocate and the learned advocate informed him that the said clerk left the profession. Stop. Thereafter, on getting the case records returned, the appellant petitioner contacted another learned advocate to get the case file, and he got the same in the last week of April 2025. In the month of May, when a notice was received from the trial court regarding execution, and he informed the learned advocate about the same, the learned advocate advised him to prefer a second appeal before this court. Upon considering the grounds furnished, this court is of the view that in the interest of justice, the application for condonation of delay should be allowed. Thus, the delay in filing the appeal is condoned and the appeal is admitted. The delay is condoned. Appeal is admitted to get it in. The appeal be placed before the Honorable Division Bench having determination in the matter for the purpose of admission.
But can 1 and 3 both may be disposed of because both are.
As the deficit court fees is not paid and the appellants have prayed for leave to deposit the deficit court fees.
We have deposited. After deposit, we have filed this application.
Yes, can 3.
Can 3. That is can 3.
Okay. As the
paragraph.
Can 1 is for deficit
Can 1
court
is
fees.
for 1 is for condonation of delay.
And can 3?
Can 3 is for not accepting the deficit court fee and condone the entire delay.
Yes, the deficit court fees
was paid
already deposited,
on
is
31st.
accepted and regularized.
Right. But 1 and 3 both may be disposed of.
Yes, 1 and 3.
1 and can 3. Can 1 and can 3.
Yes, yes.
Both may be
Can 1 and can 3 of 2026.
1 to 25.
Can 1 is of 25.
Can 1 of 2025 and can 3
of
2026 stands disposed.
Deep level.
Now for the appellant, my lord. But can 1, my lord, is my lord, my application under section 5, my lord, for continuation of my lord, delay of my lord only 38 days, my lord. But the grounds, my lord, starting from my lord, paragraph
Yes,
11 on.
complete upon the respondents.
My lord, we have submitted late by Mr.
Service
is complete.
All the respondents.
Yes. Two respondents, upon both of them, the service has been complete, effected. This is an application for condonation of delay of 38 days. Due to the illness of the learned advocate, the the appeal could not be filed within the
Can 1.
Can 1, my lord.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Let the affidavit of service filed be kept with the record. The application for condonation of delay is taken up for consideration. Heard learned advocates and peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court finds that the appellant has furnished sufficient grounds for condoning the delay of 38 days. Thus, the delay of 38 days is condoned. The application Can 1 of 2026 stands disposed. The matter be placed before the Honorable Division Bench, having determination in the matter for the purpose of admission of the appeal.
I'm grateful.
35, I am for the appellant petitioner. I am filing my affidavit in opposition. Your Lordship, my lord, indicated on the last occasion that at that time when the matter will be taken up to file the affidavit. Already, my lord, we have filed reply on earlier occasion. Let your Lordship kindly fix another.
You are for the state of West Bengal.
No, my learned friend is appearing on behalf of the state. My lord, truly speaking, may I say one thing, subject to what falls for my lord's
Now,
kindly.
which application I have to take up today?
My application for injunction.
Can 3.
Can 3. Act to Bolenia. Your Lordship kindly see the order dated 11 December 2025 with regard to Can 3. I filed an application that during the pendency of the appeal, the respondent creating disturbance and they are trying to change the nature and character. My learned friend submitted that we are not changing the nature and character. I have pleaded also in my pleaded also, and thereafter your lordship passed an order in respect of other respondents, status quo to be maintained. This is the order. Probably it is an innocuous order. What I am praying, my lord, previously by order of this honorable court, my lord, LCR has already, my lord, reached
No,
before
which is
this
the,
honorable court.
what is the order under appeal?
Appeal remand.
Or remand?
Remand. I, my lord, preferred appeal, suit for, my lord, suit for declaration and the eviction of licensing. I succeeded. They preferred appeal. Now that appeal, my lord, allowed, remanded. Against that remand, my lord, I preferred this appeal. Now the appeal has been admitted, but during the pendency of this appeal, while the admission of the appeal, no application was filed. That is why, my lord, we filed an application for injunction. Your lordship passed an innocuous order. What I am praying that as per order of the honorable court, LCR has come. I have already deposited
Paper book to, no.
paper book. Yes,
Paper
that's what I am praying. Let me dispose of in terms of this order and paper book to be filed within such date. I think it will be. Only one thing, your lordship may kindly come to my affidavit in opposition, page 12, paragraph 21. Page 12, paragraph 21 of the affidavit in opposition. Because I have taken also the specific instructions from my clients as to whether you are in any way changing the nature and character of the suit property. 12. 21. 21.
Who are affirming,
Yes.
are not in any way changing the nature,
Nature and character, I have admitted.
and not to part with possession also.
Yes. Therefore, my lord, only thing is that if the lower court records have arrived, already
So
necessary.
your object is to occupy the suit property, okay, till the disposal of this appeal. In the event if you succeed in the appeal, your learned friend fails, you will continue. And if you fail, then you have to vacate. But in the meantime, there should not be any third party.
Third party.
That is the thing. Yes, you have. But you have anything to say? Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. As the trial court records have come,
Yes, yes, as per
as the
earlier
trial
order.
court records have come, let the paper books be filed by the appellants within 4 weeks.
Informal paper.
Let the informal paper books be filed by the appellants within 4 weeks.
4 weeks probably.
Incorporating all the relevant
Incorporating,
It will take time.
incorporating.
Otherwise, this will be
আচ্ছা
very
তাহলে
difficult.
4 weeks এর জায়গায় 6 weeks করে
Yes, 6 weeks may taken.
incorporating all
Probably
the
6
documents,
weeks will not be suffice.
documents of the trial. Yes,
Probably 6 weeks will not be
In
suffice.
my affidavit in
Because-
opposition, I have almost given 90% of the
আচ্ছা
documents.
8 weeks করে
It is good.
8
I have given, that's the reason I
incorporating
have
all
filed
the
affidavit
relevant
in
documents
opposition.
of the both the trial court and the first appellate court.
Yes.
The interim order granted earlier shall continue till disposal of the appeal.
Yes. Well, it will suffice.
Yes, liberty to mention.
Yes.
Opposition may be kept.
My lord, the affidavit in opposition may be kept on record.
The affidavit in opposition file be kept with the record.
Oh, yeah, it will appears.
I'm appearing, my lord, on behalf of the appellant insurance company. Mr. Roy is appearing on behalf of the claimant's respondent. I have served upon him, my lord. Can 3 is my application for condonation of delay. And can 1 is my application for stay.
And can do
Can 2 ta kya?
Can do lawsuit, I have filed one application for expressly hearing.
My lord will, there's a very short point involved in this matter, my lord. My lord will fix it up for hearing. In the meantime, I shall prepare the
Is
paper.
there any chance of settlement?
No lawsuit.
Driving license round is there. My lord will fix it up for hearing. In the meantime, we shall prepare the paper.
Yet din oy
And I shall also.
section 5 application টা
About the education.
Can 3. My lord will kindly take my application, my lord.
Yes, record and order. Learned advocate for the appellant insurance company and learned advocate for respondent number 1 and 2 claimants are present. The application for condonation of delay being Can 3 of 2025 is taken up for consideration. Heard, learned advocates peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the appellants have furnished sufficient grounds for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay being Can
1.
No,
Stay is Can 1.
Can 1 of 2025 is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated
আপনার কিছু নাই শেষ হবে ব্যাপারটা
12/4.
লর্ডশিপ
My lord.
Yes, date of the judgment and award.
30th of April 2024.
Judgment and award. Wherever state, which paragraph?
In my memo of appeal, my lord, the true copy of the judgment is there, my lord.
Okay,
30th of April 2024.
30th of April 2024.
My lord.
Passed in MSC case number 58 of 2019, passed by the learned additional district judge, Third Court, Tomluk, Purbo Medinipur. Stay for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of the appeal. The Registrar General High Court Calcutta is requested to invest the sum deposited in a fixed deposit of a nationalized bank and renew the same from time to time. As the claimants, respondents number 1 and 2 are present, service of notice upon respondent number 1 and 2 are dispensed with. The paper books or the trial court records.
Not require lordship, the all papers with us.
The paper books be filed by the respondents, claimants 1 and 2 within 4 weeks, liberty to mention after 4 weeks.
My lord will fix up a date.
After 4 weeks, let him prepare and then
It was only the issue after the submission of insurance company. I have nothing
yes,
to
but
say.
one thing, incorporate all the documents.
Yes, yes,
If
yes.
the vehicle owner has filed a written statement, please incorporate that.
Yeah, all the papers I have included.
Sometimes I find from the order, vehicle owner has filed written statement, but not incorporated in the paper.
No,
book.
that question doesn't arise.
Anyway, please see.
Lordship, kindly March 20, March 20.
March
20. Oh,
Liberty diction to mention.
After 4 weeks, you mention.
Grateful, my lord, deeply obliged.
My lord, this is the appeal of insurance company. There is a death case. I have come up against an award of rupees, 54 lakhs 78,000, 55 lakhs, approximately principal sum. The entire awarded sum with interest is secured before my lord's court,
Is there any chance of settlement?
No, no. This won't take long before your lordship. I'll try to be as succinct as possible. I have come up mainly on the point, that this accident was not a case of accident, it was a case of murder. And if I can show it to your lordship, that if it is a murder simpliciter, then mere involvement of vehicle would not do. And insurance company in that case, in case of murder simpliciter, should not be made responsible to pay compensation. But my entire case is based on the police report. Otherwise, there is the vehicle was there was an eyewitness, but whether it was intentionally used to kill that person or not, that is the point. It was deliberately used to kill one particular individual, knowingly and fully well that yes, I am killing this person. Whether in that case, when it is a case of a murder, whether insurance company shall be held responsible or not,
With regard to 304,
lordship,
there is a division bench decision of presided by Justice Bhaskar Bhattacharya.
Lordship.
Probably you consider that if that can be, if that is applicable, we will have to follow that.
Your lordship knows that.
Justice Bhaskar Bhattacharya's judgment.
Lordship.
Let us consider
Lordship.
that. Come with the decision, let us see that.
Yes, I have brought.
I don't know the citation. Long
that decision is here. That decision is here. What I say, I'll just indicate to your lordship. There is another point of with regard to the consortium. The children were granted consortium. It's a very minor issue. 80,000 extra was.
Today I was considering a decision of the Honorable Apex Court, unreported decision, where the Honorable Apex Court,
my lord,
you see, have considered this Nanuram Pranay Shetty.
Yes.
And then stated that the high courts and the tribunals shall grant consortiums.
Lordship.
All.
Now, again, I go back to the original question.
So,
yes.
now
Yes. Yes.
Is that judgment binding upon this court?
May I reply, Milord?
If it is binding,
yes,
then I am bound by that.
Milord, may I give the reply?
Yes.
Milord, whether a 3 judges or a division bench judgment can overrule a constitutional bench judgment.
How can I decide that?
Milord, my lord will have to select. Milord,
Their lordships, 2 judges bench consider Pranay Shetty.
Yes.
All consortium.
Yes.
And it's not that it is held that under 142 we are
Lordship.
considering this.
Lordship.
You see, in several decisions,
Lordship.
Honorable Supreme Court has
Yes.
considered.
Yes.
Okay. Considered and awarded consortiums.
Lordship.
They kept untouched the other judges.
I understand.
But this judgment, the court directed the tribunals and the high courts to award consortium.
Milord,
direction.
Milord, I understand. Milord,
Otherwise, you see, If it is binding upon me, I'll have to send it to the division bench.
Your lordship will kindly do that. My lord will kindly do that
To that
because,
aspect.
yes, my lord, because, my lord, we have 2 division bench judgments, which my lord is not following. A division bench presided over by Honorable Justice Dipankar Datta said that consortium should be, my lord, I have shown it to your lordship, my lord, that consortium should be confined to the spouse. A division bench judgment presided over by Honorable Justice Sonjeev Banerjee, which has considered now, both of them have considered Nanu Ram and subsequent others also. And Honorable Justice Banerjee also, my lord, in division bench, was of the opinion that consortium should be confined only to spouse. So, my lord, today, as of now, my lord is having, my lord, one 5 judges constitutional bench judgment of Supreme Court. My lord is having 2 division bench judgments of this honorable court. Both of them have not been overruled by their respective courts. 5 judges constitutional bench Supreme Court is not overruled by another 5 judge or more bench. Division bench, 2 division bench of this High Court have not been overruled by any other division bench.
Now the view of the Honorable Apex Court is this: parental care should not be granted, but grant consortium. This is the clean language. Very simple language.
With the greatest of respect, my lord, we go back to the original question. My lord, my difficulty today as a counsel before your lordship, my lord, to address my lord, and my lord, request and pray before your lordship to follow a 5 judges bench judgment or a 3 judges bench judgment. My lord, what we have learned till date by from your lordships, my lord, that we always go by the bench which has a higher strength. If the point remains same, if the issue remains same, issue by 5 judges was of consortium. They have dealt with, my lord, various judgments. The judgments by 3 judges bench also they have dealt. And then they said that no, general damages should be confined to 70,000 with 10% increase. My lord, I asked this question to myself. Are we confining general damages to 70,000? In some of the cases, no. Supreme Court, in other cases, division benches and 3 judges benches, they say that no, we will increase the general damages by giving consortium to some other persons, which the constitutional bench had not provided.
See,
lordship.
See, observation is one thing, but the moment one word is used, the tribunals and the High Court shall grant consortiums on these aids. One line is there. Had this line not been there?
My lord.
It is on 142.
My lord, then my lord is perhaps, my lord, perhaps overlooking paragraphs 15, 16 onwards to paragraph 27 of 5 judges bench with regard to the judicial propriety. The 5 judges bench sat together and they say that when a constitutional bench passes an order, it is absolutely binding upon all other courts, including Supreme Court. Now, my lord,
the subsequent
lordship
judgments of the bench
of lesser strength,
my lord, can be avoided. Is it open to us that yes, you can avoid that, even if it directs you something, even if a lower bench directs me something,
lordship.
Can I avoid that? No. It
yes, in view of the constitutional bench judgment. Yes, my lord has got, two options: to follow the constitutional bench or to follow a division bench or a 3 judges bench. If 3 judges bench does not, on the same point, the point is only consortium. If the 3 judges bench or a division bench of Supreme Court does not confer to the same point, same issue of the constitutional bench.
If there are some decisions that yes, if a decision of that bench, a bench of a
lesser strength,
lordship, after considering the constitutional bench,
lordship,
modifies something,
lordship,
directs something,
lordship,
whether that can be avoided or not.
Yes, my lord, this particular issue, whether that can be avoided or not, has, my lord, at the cost of repetition, my lord, I say, has been answered in Pranay Sethi itself from paragraph 16 with regard to judicial anarchy, with regard to judicial propriety, and with regard to my lord, to bring, my lord, a judicial discipline. This is what their lordship, my lord, in the constitutional bench have said. In that very judgment, my lord, I need not trouble your lordship with other 5 judges, 7 judges or 9 judges bench on this issue, because that particular bench itself says that why it is to be followed and why not Nanuram, or for that matter Satavant Kaur, or for that matter other judgments are not to be followed. It had said so. My lord, had it not dealt with that, had it not dealt with the judicial propriety, my lord, I wouldn't have been troubling your lordship. My lord, I'm paying 1 crore. 40,000 doesn't make any difference to my client. But, my lord, I am on the point of principle, whether your lordship today, my lord, would follow a 5 judges bench and the division benches of this honorable court, which have considered the constitutional bench as well as the subsequent, my lord, they have considered. Honorable Justice Dipankar Datta considered, Honorable Justice Sanjeev Banerjee considered, and then they came to finding that no, we in High Court, we should follow constitutional bench of Supreme Court. We will not follow the benches of the lesser strength of the Supreme Court. That's what they, my lord has seen that, my lord. It was a specific finding. So today, my lord, when my lord is, my lord, not following the division benches of this honorable court, which have not been overruled, my lord, there is another difficulty for us. My lord, we are citing judgments to your lordship, my lord, to come to a specific finding, my lord, so that we are also sure on this side, my lord. Every day, my lord, troubling your lordship, my lord, he asks for, my lord, 40,000. I say this 40,000 cannot be granted, whereas I am paying him a crore. But I am raising this issue on principle that this 40,000 cannot be granted.
Issue has to be settled.
Issue has to be settled, my lord. And, my lord, in my humble submission, when 2 division benches have settled this issue on this very score, then, my lord, I am troubling your lordship. But my lord is sitting on a single bench, my lord. Why am I troubling your lordship again and again on this issue? And Supreme Court, my lord, let another 5 judges of Supreme Court say, Pranay Sethi, throw it away. My lord, I will not be bothering your lordship at all. For any matter, for, my lord, this issue, my lord, would come to an end. But, my lord, a bench of lesser strength says that I will overgo and I will, my lord, overpower, or I will, my lord, go beyond the constitutional bench on the issue which has been decided. Then, my lord, it creates difficulty for us as a council on this side. This is not only Motor Vehicles Act, or for that matter, there are so many other acts also. If the constitutional bench is not followed, and if the bench of a lesser strength says that no, we say that we will not follow that, we go beyond that, and the other honorable courts are to follow this, what would be the situation of the country there, my lord? Where will the law stand? Where will the finality? Every other day, somebody or the other will say that no, constitutional bench, let them decide. We will decide otherwise. Then what, where is the final outcome, my lord? Because every other day somebody, my lord, I have told to your lordship, my lord, and I have shown to your lordship, future prospect has not been granted after taking note of Pranay Sethi. The judgment is shown, my lord asked not, I'll show it at 2 o'clock. Then again, considering Pranay Sethi, future prospect is not granted. My lord, in so many cases, my lord, multiplier is deferred from Pranay Sethi. There are so many cases, my lord. But, my lord, we do not come up and trouble your lordship on every single occasion that no, your lordship will kindly, my lord, follow the subsequent judgment and reduce the multiplier or not grant the future prospect. Or, my lord, in so many cases, my lord, this disability part, my lord, is taken care of, nothing is granted. We do not trouble your lordship, my lord. We say that no, your lordship, my lord, for once, decide the constitutional bench. We all on this side are safe and secure. My lord, we come to a finality. Yes, Pranay Sethi is final. My lord, we are following Pranay Sethi on multiplier. We are following Pranay Sethi on future prospect. We are following Pranay Sethi on, my lord, personal deduction. But, my lord, we will not follow Pranay Sethi with regard on consortium. Why, my lord? I keep on asking this question and I do not get the answer that how come, my lord, here a division bench or for that matter a 3 judges bench says that we will not follow Pranay Sethi. My lord, let them not follow Pranay Sethi. They are sitting in Supreme Court. My lord, they have got, my lord, the plenary jurisdiction, my lord, under 142, whether it is spoken or whether it is not. 142 they always have for the ends of justice, Supreme Court. My lord, it is not, my lord, necessary. They have to put it in writing that herein I am using 142. In Nanu Ram, they have used the term that I am following, my lord, we are following under 142. And this 142 was taken note of by Honorable Justice Sanjeev Banerjee. Sanjeev Banerjee, my lord, his lordship as then was, his recorder, my lord, recorded that Nanu Ram, my lord, notes that under 142 they are passing this order after considering Pranay Sethi. Therefore, we will not follow Nanu Ram for that matter. And all subsequent judgments, they all refer to Nanu Ram. Original, my lord, where this story started was Nanu Ram. Nanu Ram, my lord, in the judgment itself is written 142. Their lordships have recorded that in Supreme Court. Our High Court took note of that division bench and said that Nanu Ram is 142. We will not take care of it. We will follow Pranay Sethi. Justice Dipankar Datta, my lord, as his lordship then was here, my lord, he also took note of that 142. In his judgment, it is recorded. And he said that no, we will not follow Nanu Ram. And all subsequent judgments of Supreme Court, my lord, they are following Nanu Ram. Original.
Is also there.
Yes. They originate from Nanu Ram. Justice Rohington, my lord. He was the first one who deferred. And he said that we feel that extra should be granted. All other subsequent judgments which are differing from Pranay Sethi, they are following Nanu Ram. And Nanu Ram originates from 142. So it is inherent. 142 is inherent in all these judgments, my lord. And now whether my lords, my lord, today in the appellate jurisdiction have got the power, my lord.
Exercise of the power of the 142.
I'm grateful to your lordship.
Supreme Court can fix any amount, quanta.
Yes. They can do whatever they like.
The Honorable Supreme Court directs courts and tribunals to do something. So that is not 142. That is also a direction.
But my lord, then what about paragraph 61, the penultimate paragraph of Pranay Sethi, that we say that this should be followed? 1, 2, 3, 4, 5, 6, 7, 8, 9 points.
So we have to apply.
So your lordship, my lord has to
think which one.
my lord has to consider, my lord, because
you see, 142 deciding under 142 is one thing.
Yes.
And directing the courts and tribunals to do something in that particular decision,
but my lord,
that is another thing.
I'm extremely, my lord, I have understood, my lord, the difficulty, my lord, what we all are facing, my lord is also having difficulty. But my lord, my lord, when my lord, your lordship will kindly pardon me, when a bench of lesser strength directs that one particular, my lord, principle to be followed,
that was before the bench.
My lord, they did so. But my lord,
okay.
My lord, we are.
Suppose something is before you, you have some power to do.
Yes.
You do something.
Lordship.
Okay. But your subordinate may not do that.
Lordship.
But the moment you direct to do something
Lordship.
in a particular way.
Lordship.
So then that is a direction.
But my lord, that direction does not follow the earlier constitutional bench finding
That was very well followed.
No, it does not follow it, my lord.
No, in another decision, not Nanuram, another decision. Consider Nanuram, Pranay Sethi, and direction. Yes.
I understand, my lord. I understand, my lord. What was not followed, my lord? On that aspect, I am saying that when a direction was passed that grant more money under consortium over and above spousal, my lord, this granting of more money, my lord, does not confer to the Pranay Sethi part. Their lordships in Supreme Court, my lord, have all the powers to grant this, and their lordship have, my lord, directed the, my lord, the other courts also to follow this particular, my lord, judgment. My lord, I will show your lordship after passing of this order, the one what my lord is referring to, there would be judgments, and there are judgments which again confined to 70,000. Then, my lord, then again the difficulty arises because some honorable courts would still say we would follow Pranay Sethi. Because Pranay Sethi, be that as it may, we accept, we don't accept, my lord. It is a constitutional bench, and in paragraph, my lord, they have pointed it out after dealing the issue of consortium. Rajesh, Rajveer, Santosh. And they have, my lord, the definition of consortium, my lord, including Black's, my lord, dictionary has been mentioned there, what the consortium word means. When 5 judges bench, they sit together and they say that the meaning of consortium is this. And we sitting together, we come to a particular finding that this is the meaning of the word consortium. Further, a division bench is expanding that meaning. My lord, in my humble submission, my lord, I think it is not permissible in law. But Supreme Court is Supreme Court. They can always say, my lord, we do not follow the other judgment. We will follow on my own. We will follow this. We will grant more compensation. Or we will grant something extra. But today, other than Supreme Court, whether all other courts would follow, my lord, it is up to your lordship to decide whether my lord will follow a 5 judges bench or whether my lord will follow a judgment of a lesser strength. My lord, had it been a writ court, my lord would have had the plenary jurisdiction. For ends of justice, my lord would have, my lord, granted whatever. Writ court can, my lord, grant in the jurisdiction, my lord, plenary jurisdiction. But in appellate court, my lord, these judgments, when they are there, my lord is to confine, my lord, that this extra power, or my lord, extra amount, whether to be given over and above 5 judges bench for ends of justice, whether this would do or not. Your lordship will have to, my lord, a serious think on this, my lord, because this particular court, Honorable Justice Vivas Pattanayak, my lord, specifically took this issue. And my lord, his lordship, after considering all other judgments, my lord, starting from Pranay Sethi to our 2 division benches, and then my lord, Nanu Ram, Satwant Kaur, and other, my lord, 3-4 other judgments which had differed from Pranay Sethi. My lord, his lordship was of the view, in the Banasri Pathak's case, my lord. His lordship, my lord, is a very detailed and reasoned judgment, my lord. I had handed it over to your lordship. If my lord asks me, I'll again give it to your lordship. But it had very clearly and categorically said the Supreme Court can give whatever orders they want. But today in High Court, when we are, my lord, facing this difficulty of having different judgments of Supreme Court, we would go by the constitutional bench. Make it very simple and uncomplicated. Let another bench of larger strength of Supreme Court come up and say, then, my lord, then we are bound by that. But, my lord, this, my lord, as I was, my lord, submitting before your lordship, the aspect of judicial discipline, my lord, would otherwise, my lord, would have no value. Otherwise, 5 judges bench, my lord, if we start differing, then, my lord, the law would not have any finality. Every single day, my lord, something or the other is coming up. My lord, some is saying that give it to children. Some is saying give it to parents. One has even given it to mother-in-law. So, my lord, if we keep on extending, my lord, then what happens to the original judgment from where it all germinated, my lord? Then penal has to be given a go by, and then, my lord, for every single aspect, we will argue before your lordship by taking refuge of all other judgments of Supreme Court where they have differed from penal my lord, we will keep on challenging your lordship, my lord, for every single issue, which today we are not. My lord, there are certain judgments which are in favor of the company also. My lord, as I stated, no future prospect, multiplier reduced. So, my lord,
That is lesser number. That is lesser number.
I'm thankful to my learned friend. That is lesser number.
Yes.
Lesser number of bench.
My lord is correct in your lordship, because your lordship knows that the Bhaktavias case, there was 3 judges bench. After that come Helen C. Rebello. Bhaktavias case has been distinguished by Helen C. Rebello, 2 judges bench.
On what point, my lord? Let him explain. I'll give the reply, my lord. Not on the issue, not on the issue which has been decided.
My lord, after that, my lord, since this is beneficial legislation.
No, facts, if the facts differ, okay?
If the facts differ, yes.
Definitely.
Yeah, definitely, my lord. But if the facts remain same and the issue has been my lord, decided by the constitutional bench, whether those can be reopened and, my lord, extended or reduced by a bench of a, my lord, smallest tenth of not, my lord. My lord, the issue, my lord, the core issue remains the same. The meaning of the word consortium and to whom it can be granted. And thereafter, my lord, it was confined to 70,000. Again, my lord, my lord, there's another aspect. 70 is given, it is written over there. And it is said 10% increase every 3 years.
20,000 and 84,000, not much difference.
My lord, I'm saying that 70,000 with 10.
84,000.
My lord, that is what.
That is a percentage increase.
That is what Supreme Court has said. 70,000, then 77,000, then 80. My lord is absolutely correct. We are not deviating from that. If we are not deviating from that, then why we are making this 70,000 to 1,10,000?
No,
or for that matter, my lord, 1,50,000?
That is correct to the extent that when lesser bench has been passed after considering the decisions of the earlier decision. Yes.
Lordship. Your lordship, my lord, will kindly keep in mind whether constitutional bench orders can be deferred or not by virtue of or on the basis of a decision which is passed by a bench of lesser strength.
Usually it is not deferred in any other fields.
Yes.
It is only in this motor accident claim.
My lord, motor accident claim cases, my lord.
All other cases you see 99% or 95%, it is not deferred. Higher benches decision.
And my lord,
it is only this field, it is an
yes. And my lord, in cases, my lord, in cases where if my lord finds any difference has been made or any judgment has been deferred, any other act, my lord, what my lord would do, my lord? My lord would simply follow the larger bench.
See, mostly that is done, and hardly you find in other fields there is a.
My lord, even in exceptions,
very hardly you will find. Whatever deviation you will find, okay. Even in High Court, Supreme Courts and all, that is in this motor accident claim cases.
And my lord, before your lordship, my lord, there are 7, 8 honorable benches.
So you see, we are not satisfied ourselves whether
Yes.
we have done justice.
I understand, my lord.
That is why we always are answerable to our conscience.
Yes.
Always we think that
I
we have
understand.
not done justice. That is why we enhance the amount.
Yes. My lord, I understand, my lord.
We ask ourselves, above all, our conscience. So you find 90% of the deviation is there in this motor accident.
Yes.
Other fields you hardly find.
We find any, my lord.
Very
Hardly. Yes. I mean, this is also creating trouble for us as well. My lord, when at the time, every time, my lord, why I appear before your lordship, my lord, the difficulty is, my lord.
Motor accident claim cases, to some extent, this interlocutory matters, bail matters, to
But
some
my lord,
extent.
your lordship, my lord, has, my lord, the word fallen from your lordship, my lord, was with regard to the beneficial legislation. But, my lord, when my lord is passing an award of 20 lakhs, 50 lakhs, 80 lakhs, my lord, whether this 40,000 really makes a difference, taking, my lord, this refuge of beneficial legislation, I put this question to myself. Had it been 1 lakh, had it been 2 lakh, my lord, then I would have understood, my lord is granting them 40,000 more. Had it been 5 lakhs, then also I would have understood, my lord is granting them 80,000 more. But when it is a crore, And then, your lordship, my lord, the fight starts for 40,000, and the fight is whether to follow the constitution bench or not.
40,000 or 50,000 will not cause any difference.
That's
That
what I
is to
say.
Company, not to the
That's
claimants.
I'm exactly on that.
That is why you see, but whether we ask ourselves whether we have done justice or not.
Yes, my lord, my lord is absolutely correct. My lord, that is why I also ask myself, when, my lord, we are giving them 70 lakhs, then why am I fighting for 40,000? My lord, the answer to my question, my lord, I say that it is not 40,000. It is the integrity, and it is the might, and it is justice, my lord, the majesty of the constitutional bench I am fighting for. I am fighting for what 5 judges of the Supreme Court of our country have decided. I am not fighting for 40,000. I have given 70 lakh. I have given 40,000 more. And if the question of beneficial legislation comes to my lord's mind, then in 70 lakh or 50 lakh or 30 lakh, this 40,000 would not make any difference. It would make a difference if it is 1 lakh, 2 lakh, 3 lakh. Then I would understand again, my lord, that yes, the amount is very, my lord, meager. Let them get this extra benefit. But when amount is huge, then why we are not following Honorable Supreme Court of the Constitutional Bench, my lord? Then this is what is troubling me.
Right.
My lord, I'm not paying from my pocket, my lord. Company is paying, fine. So why are we arguing for 40,000? We are not arguing for 40,000. We are arguing for the majesty of constitutional bench.
So that there is a parity.
Yes, so that there is a parity, and every single case, my lord, we come up. Children will get, mother will not get, father would not get, sister would get. My lord, why are we, my lord, coming up with this issue again and again? Supreme Court is very clear on that 70,000 is the sum, 77 or 84 with the, my lord, passage of time. Don't increase this 70,000, because, and there also, my lord, Supreme Court has said that other aspects have taken care of. This is something extra granted, because, my lord, loss of dependency is calculated, is given. This is under non-pecuniary. And under non-pecuniary, my lord, the ceiling is made 15, 15, 40. And 40 also only to spouse. That is why the total is 70. My lord, when this periphery is made, then, my lord, how come, my lord, one breaks this periphery and says that no, I am over and above the constitutional bench because it is beneficial. My lord, this, in my humble submission, my lord, this should not be done. More so when the constitutional bench has answered all these queries with regard to judicial discipline in that very judgment from paragraph 15 onwards, my lord. Your lordship will kindly, my lord, kindly have a look at paragraph 16 onwards of that judgment, plenary sitting, my lord, where their lordship, my lord, taking note of all other earlier constitutional bench judgments and 3 judges bench judgments, have said that why this discipline is to be maintained. Because the trouble was, before plenary sitting, every other court was coming up with different figures. My lord, for him being a judge, my lord, 1 lakh was sufficient. For me being a judge, in a particular case, 70,000 was sufficient. And for one Mr. X being a judge, for him, my lord, 7 lakh was not sufficient. There was huge difference. Pranay Sethi said that no, nothing doing. Sarla Verma had tried to decide one thing, which is again not being followed. Sarla Verma was a division bench. There were certain 3 judges bench. They said, no, we are 3 judges bench. We will not follow the schedule of Sarla Verma. Sarla Verma, my lord, had granted 20,000, 20, for general damages. 5, 5, 10. Rajesh Rajveer, my lord, which dealt with consortium, 3 judges bench, my lord, it enhanced it like anything. My lord, other than, my lord, except the other parts, consortium, minor children were granted 1 lakh each. Some other courts, my lord, were following Sarla Verma. Supreme Court. Some other were granting 40,000, 50,000. Then Pranay Sethi said, what is this happening? We have to use the rule of thumb and we have to come a particular figure. As far as, my lord, quantification, my lord, with regard to loss of dependency, formula was set. We all are following that. And with regard to general damages, again, for the discrepancy for not following Sarla Verma, because 3 judges bench said that we are over and above.
Part of the pronunciation is Sarla Verma.
Part of the pronunciation is Sarla Verma. Yes. Sarla Verma, my lord, is a very comprehensive judgment. But that was again not being followed. Sarla Verma 2008. Subsequent judgments were not following Sarla Verma. Then this, my lord, Pranay Sethi, my lord, they said they sat together and they said that no, let us fix it up. Let us come to a particular finding every other day. What is happening? Throughout the country, there is a judicial anarchy. Supreme Court itself is not following. So then they decided that no, let us follow this schedule and formula of Sarla Verma to the maximum extent. And with regard to general damages, which was creating trouble, that was one of the core issue. They said, let us fix up the periphery of 70,000. And then again, my lord, another division bench comes up subsequently, or a 3 judges bench, and says that no, we will now go beyond this planacity. This is a never-ending process, Millard. This is never-ending process. So that is why, Millard, our division bench said that no, we would rather go by the constitutional bench. And before that, Millard, all other, Millard, our other earlier honorable judges, Millard, they all have followed, Millard, that yes, let us follow, Millard, constitutional. And there is, Millard, nothing wrong. I don't find any wrong in that, Millard, following constitutional bench. Because, Millard, every day, Millard, when this definition of, Millard, this consortium would increase, Millard, it would increase for the persons who were dependent on the income of the deceased. As I said, Millard, this consortium was increased and taken to the extent of mother-in-law. Tomorrow, all brothers, all sisters, all children, even uncle, aunts, Millard, father-in-law, grandchildren, Millard, if each one of them is dependent and if they are a party to the claim application, everybody is entitled. Even the servant, if he can show that yes, he is also a part of legal representative and he is also, Millard, is suffering for the loss of dependency, he is also entitled. Millard, how far would we stretch this? Is this upon the, Millard, upon an individual, Millard, honorable judge to decide, no, I will stretch it to this far, I will stretch it to this far, when the periphery has already been made, Millard? 70,000 is amount is mentioned, Millard, 70. Then, Millard, the Honorable Supreme Court should have been conscious enough to include others. It decided not to. Millard, may I put this question to myself? The children were not granted. Does it mean that the father would be given? Father otherwise, who is not entitled for compensation under, Millard, Hindu Succession Act. My Lord knows. In case of death, Millard, of an individual.
That is in different decisions it is decided.
Millard, I'm coming to the Hindu Succession Act.
Yes.
Millard, if X dies, father is not entitled. Mother gets, the widow gets, if a person is a male, Millard, male Hindu dies. Father is not consciously. It is still the law of the land.
That is there.
So, Millard, here, then, Millard, the father is also included at times. Because we are not strictly following, Millard, the
judicial decisions, father is granted. Mother was there always.
Mother was always there. Widow is always there. Children are always
Father
there.
is granted after following.
Millard, then, Millard, what stopped the larger bench, the constitutional bench in Pranay to not to give any money to the children or to the mother? It was a very, very conscious decision, Millard. When it was consciously decided, then how come, Millard, it is being expanded?
Anyway, that we have to consider.
Lordship will kindly consider
some
that.
other
Yes.
Similar issues. One issue is before me. Anyway.
Millard, coming back to this case, Millard. Millard, as I stated earlier, Millard, this is a death case. An award of, Millard, 55 lakhs principal was passed. Millard, the money is secured by the insurance company before my lord. Millard, I had taken. Millard, I had taken.
With regard to the accident, issue of accident.
Millard, I say that, Millard, the police has said that it was a case of murder. For the charges and for the section, Millard, it was slapped against the driver and, Millard, some other persons. So if it is a case of murder or murder simpliciter for that matter, Millard, that is what, Millard, I have relied upon, Millard. Then insurance company should not be made liable to make compensation. Then, Millard, my lord referred, Millard, that reference of Honorable Justice Bhaskar Bhattacharya's judgment, Millard. Deepa Ganguly.
Now you see, earlier this 304 was
Lordship.
Is added.
Lordship.
Instead of 304A. Drivers were implicated under 304. Still, motor accident claim case was maintainable.
Yes, earlier, but now, Millard, it is 304A.
Yes, in the just few years ago, this 304 was added.
Because, Millard, 304, Millard, was referring
culpable
to the
homicide.
Culpable homicide, Millard, knowingly, deliberately. But now 304 is, Millard, is being specifically added to say that it was rash and negligent driving. He did not want to kill that person beforehand. But because of rash and negligence, Millard, the person was killed. And then, Millard, 279 is added. Because, Millard, is the punishment with regard to rash, Millard, 279 and 304A. These are the sections, Millard, which have become, Millard, a very focal point of these accident cases.
Somebody enters in a crowded place and drives rashly.
Yes.
304A was added.
I am extremely grateful to your lordship, Millard. Yes. Then 304A, my lord. Because maybe because of the accident, my lord, not amounting to complete homicide, my lord. Not maybe, my lord, because of the accident, my lord, some persons were killed. But it was not in his mind. When he started driving, my lord, he did not make it sure that I have got to kill Mr. X, I've got to kill Mr. Y. It was not pre-planned. That is why 304 is not there.
Here you see, police authority has given charge under 302.
In this case, my lord, 304.
304, yes, that is what I'm telling.
And 120B.
302 is one thing.
Yes.
300, so many cases are given under section 300.
That is plain simplicity, Mara.
Because you see, to make it a very rigid.
Yes, very rigid.
Very strict.
Rigid.
This 304 was added.
My lord, in this case, my lord, 279, my lord, in this case, my lord, 120B is also there. Criminal conspiracy. The moment, my lord, it is a criminal conspiracy, my lord, it is not only rash and negligent driving. My lord, the criminal conspiracy means, my lord, it was pre-planned, it was already decided, and more than
or just a car.
My lord, the victim, my lord, was driving a motorcycle who died.
Okay, and
he was hit by, my lord, one dumper of, my lord, a big vehicle dumper, my lord, a 16-wheeler vehicle.
And the driver was charged under 304.
Yes. And 120B.
So 120B means there must be co-accused, other co-accused.
I'm extremely grateful to your lordship. My lord, the moment it is 120B, my lord, it makes, my lord, it a criminal conspiracy. My lord, I'll, my lord, indicate to your lordship, my lord, if my lord is kind enough to come to page number, my lord, 16. My lord has the paper book, my lord.
Yes.
My lord, I'm straightway inviting my lord, there to the evidence of the police.
Yes.
On which, my lord, I am relying, my lord, heavily. My lord, may I read?
Yes.
1616, my lord. I performed duty as second IO of this case. I submitted charge sheet in the said police station case. Initially, the police station case was started under 304. Subsequently, I have submitted charge sheet against accused 1, 2, and 3 under section 304 and 120B. This is what I was submitting, my lord.
So what is the FIR? Let us see.
Lordship, my lord, FIR is, my lord, at page number 38. My lord, FIR was a delayed FIR after 3 days, my lord.
Yes.
It's, my lord, at page 38.
Yes.
My lord, the written complaint, my lord, which is annexed to the FIR, is at page 4040.
Yes.
My lord has seen, my lord, last but 2 lines, my lord.
Yes.
My lord has read that, my lord. ষড়যন্ত্র?
Yes.
থাকতে পারে আমাদের মনে সন্দেহ এর ভাই বলছে
Only vehicle number, no accused name is there. FIR name accused person.
No. Vehicle number is there, or ষড়যন্ত্র থাকতে পারে. The brother of the deceased is saying so.
And where, yes.
And this, my lord, this is not.
FIR named accused person is not there. Who is the
No, that is
conspirator?
not. That is what police is confirming, my lord, subsequently.
Because sometimes in the FIR, names of the
Sometimes,
accused are
yes,
given.
yes. So, my lord, when
What is the eyewitness statement?
my lord, eyewitness, my lord, is at page number 11.
Yes. The FIR was lodged after 2 days,
Yes, after 3 days, my lord.
3 days, and the vehicle seized after.
My lord, the charge sheet, which is
Caesar
here
list is
that, my
there,
lord,
right?
is at page number
53 Caesar list.
53 is Caesar list, my lord. Charge sheet starts at 42.
52 and 53.
52 and 53. August, my lord.
After 3 days.
No, my lord.
No.
My lord, accident was 15th of March.
Yes.
And Caesar was 11th of August.
And FIR?
FIR lost after 3 days.
Yeah, and this driver arrested?
Yes. He has been fined, my lord. Kindly
Yes,
see-
driver arrested.
Arrested.
When?
My lord, may I invite your lordship, my lord, to the charge sheet, which is at page number, my lord, 40. Page 42 starts, my lord. And I would invite my lord, to the specific part that is at page number 5050. The relevant part, my lord, of the charge sheet. 5050 is there.
Yes.
Internal page 9, my lord. My lord, from the second paragraph, from the statement of witnesses and recorded statement under section 164 and overall evidence collected, result of investigation, prima facie charge sheet under 304 and 120B IPC has been well established against all the accused persons, namely, my lord, 1, next line is 2, and the line after that, my lord, is 3. 1, 2, and 3 persons, my lord. As per my superior instruction, I submitted the Rampur Hard PS charge sheet number so and so under 304 and 120B IPC against the above named accused persons to face trial.
So it is also without valid driving license?
My lord, that is there. My lord, I am coming to that. My lord, this vehicle did not have the driving license and this vehicle did not have the route permit. Owner has admitted that and I have got the right to recover. I am not on that. My learned friend is also not disputing. Right to recover is there. But my lord, I am.
Is given.
Yes,
that is
has
given.
been given.
That is given. My lord, we are not troubling a lordship with that, my lord. Right to recover, your lordship will kindly confirm that. But my lord, I am not my right to recover. I am not on principle whether if it is a case of murder, whether
Owner is not implicated.
lordship.
Owner of the vehicle.
Owner of the vehicle, my lord, he was implicated.
Implicated and OPW2.
OPW2,
page 17.
No, in the charge sheet.
Charge sheet, my lord, owner is my lord Naimuddin Sheikh. The charge sheet does not contain his name, Naimuddin Sheikh.
What is OPW2?
OPW2, my lord, that is the owner, my lord.
OPW2 is the owner?
Yes.
Right, but is he implicated in this case?
My lord, yes, OPW2, my lord, not in the criminal case, but
Yes.
he is a party to the claim proceeding.
No, he has to be a party to the
Yes,
claim proceeding.
yes.
But the question is, in the written statement, he has admitted that the vehicle was without valid license.
Yes. His evidence is there. My lord, I'll show it to you.
Evidence.
My lord, your
Where is
lordship
the
will kindly,
Well,
page 17, page 17, your lordship will kindly come to.
OPW2, my lord.
Yes.
My lord, as per summons of this court, I have appeared. This is the owner of the vehicle. I have appeared to depose. The vehicle is of TC number. My lord, TC number, my lord, is a trade certificate number. It is not permitted to ply on road. It is only given to the dealers. My lord, yesterday also there was one TC number reference. Perhaps, my lord, it was not clear to your lordship. TC number is given to the dealers and then, my lord, only for their own purpose, my lord, for testing, for taking it to motor vehicle, they can use public. It is not for usage as public, for given to the public or for the end user. So it is TC number. I have brought road challan and copy of insurance policy. I have also filed documents before this court. On subsequent occasion, we have not obtained RC and route permit of offending vehicle from showroom. I have not brought the DL of the driver of the offending vehicle on the date of incident, that is on 15th March. The driver, Taiful Sheikh, had no valid and effective driving. So this is admission, my lord. There is no further confusion with regard to
Thereafter,
that.
my lord, kindly see the cross-examination also.
The documents which I have filed today, because the engine number and chassis number, as the driver had no valid DL, so he was imposed fine in the criminal case.
The
So
driver-
this is
my
flawed.
my lord, kindly see thereafter. The driver was the resident of village Serpur, district Murshidabad. The deceased was the resident of district Birbhum. The driver and deceased were not known to each other. The accident took place as usual which generally happened.
So, my lord, with regard to the right to recovery, there is an admission, my lord, we are not on that. That is there. But my lord, whether at all insurance company should pay or should be made liable to pay or not, my lord, that is the issue.
Yes,
My
that
lord,
is the.
3 days after the accident, my lord, the FIR was lodged by the brother of the deceased. The brother says there is shortage on throw. Police, upon proper investigation, files charge sheet. Charge sheet, my lord, names not the driver, but 2 other accomplices of driver as well. 3 persons. It is under 120B and 304A. My lord, 27 and 304, my lord, not 304. I'm sorry, my lord. 120B and 304. 279 is not used.
No, straight away, you see 304 is given.
Yes, state with 304 is given, my lord. So rash and negligent part, my lord, is missing from the policeman's this charge sheet. Hundred 120B is there as criminal conspiracy. So, my lord, when even 3 days after the accident, the family members say that they smell foul in this murder.
And they filed also the claim case, if their family members.
That is for money, my lord.
That is for criminal
That
case
is
as
for-
well as this claim case.
Yes, no, that is for claim case, my lord. They filed this claim case, my lord, for money part. My lord, when the family member, the brother of the deceased, after 3 days, my lord, it's not immediate after the accident, my lord. After 3 days accident, my lord, when he had ample time to decide that what had happened, my lord, he had ample time, my lord, to collect the information, my lord, from whichever sources he had, and he is smelling foul and he says that there is a shortage on throw in the death of my brother. And police confirms this shortage on throw after 6 months by filing 304 and 120B, and 3 persons have been charge sheeted. It is not the rash and negligent driving of the driver of the vehicle.
No, my lord, kindly see page 16. The police authority also said, without negligence, no accident can be occurred.
After 6 months, charge sheet submitted. So vehicle number was given in the FIR, but anyway, there cannot be any driver's name.
Lordship. So, my lord, this is what, my lord, the sum and substance of, my lord, my appeal before your lordship is.
Yes, now what is the claimants? Who has FIR maker is family member or third party?
Brother, family member, own brother of
Brother has deposed.
No, brother has not deposed, my lord.
Brother has not deposed.
So family has deposed.
Yes.
My lord, the widow has come up.
Yes. What is the deposition?
My lord, that is at page number 6.
Yes.
My lord, the murder part.
No, what is the
My lord, widow doesn't speak anything about the murder.
only accident?
Yes, only accident.
What is the cross examination?
My lord, page 9. Right, দেখুন তো।
So no cross examination that it was not an accident but a murder.
My lord, she was not even an eyewitness, my lord, so there is nothing like that.
No, this suggestion was also not given. There are suggestions given, other suggestions, entitlement, and it is not insured. Yes, so from this family, okay, this is Clement's, the victim's wife.
The victim's wife and 2 children are the my lord claimants.
Yes, now what is the statement of police authority?
My lord, kindly see page 16. Page 16, second paragraph, first line, your lordships will find without negligence, no accident can be occurred.
Oh, so this is a charge sheet.
Yes. In cross-examination, it has been stated, the police authority stated in cross-examination, without accident, without negligence, no accident can be occurred. First line.
Not a fact that without proper investigation I have submitted charge sheet. So, my lord, upon proper investigation, my lord, he has made it clear before the court. He has
Driving license, that is also not given. Oh, it
my lord, driving license owner has admitted that the
no, under the Motor Vehicles Act, that section is not given.
yes, that is not given because there was no driving license.
No driving license.
Yes, no driving license. My lord, that part is my lord, without any confusion.
The question is whether this person, the owner, has engaged is a professional driver or is a casual driver.
Well, whichever way, owner was aware of it. Owner knew that the person did not have the driving license. That concludes the issue, my lord. Owner himself comes up before the court.
No, he has admitted that he has no driving license.
He has no driving license. I need not go any further. I'm not on ration, I'm not on this pay and recovery part. We are not troubling your lordship. That is there. But my point is that I will not pay. But if I pay, if my lord holds that I have to pay, my lord, then the right of recovery is there. My lord. So your lordship will, my lord, we would not, my lord, pray before your lordship, not to go to that part because that is there. Driving that is concluded issue. My lord, my my lord, prayer before your lordship today is that whether at all I would be made entitled to make payment or not. Whether in this case the Motor Vehicle Act, my lord, the compensation can be granted or not. If it is a case of murder, if it is murder simplicity, my lord, then Motor Vehicle Act does not come into the picture.
No, my lord, under section one, my lord, that is your lordship knows that the decision of this honorable court.
My lord, if it is not murder simplicity, then my lord, the Motor Vehicle Act comes into the picture.
You see, whatever will be the findings before the trial court, that will also be placed before the criminal court also. Whatever the findings is there by this court.
Yes.
Be there.
Yes, would also be there, my lord. If my lord holds that it is not a case of murder, then my lord, this would help these murderers before the criminal court, my lord, some way or the other. Somebody, my lord, police says that in a criminal conspiracy with two other persons killed one Mr. X. Police is confirmed of that. Police has filed a charge sheet. 3 persons were charge sheeted that they formed a group together and by this vehicle they killed that Mr. X. If today my lord holds that no, it is not a case of criminal conspiracy or for that, not a case of murder, my lord, they will go scot-free.
Anyway, let us see this decision.
Yes.
My lord, before that, my lord, your lordship will kindly have. My lord, that is Deepa Ganguly. My lord, this subsequent judgment has considered Deepa Ganguly. My lord, I was only on this murder simplicity, whether in the facts of this case, whether Deepa, what's on report? My lord, whether Deepa would be applicable or not. This is judgment of 2024, my lord.
Well, let us see this
Lordship
first.
My lord, page 2, the appeal has been preferred against so and so under 166. The facts. On April 2011, my lord, I am at page number 2, my lord. Second paragraph.
Yes.
The facts. On 25th and 26th April. On so and so near Megha Rice Mill, victim was murdered inside the vehicle number so and so by miscreants. Victim was driver of vehicle number so and so, who started his journey on 25th April with his truck to load cement. Victim parked the vehicle on National Highway and Khalasi of vehicle took rest in a hotel. Victim stayed inside the cabin of the vehicle. Khalasi noticed next morning that vehicle was not there. He informed the fact over phone to the owner, who found the vehicle in front of one rice mill, and dead body of the victim was found inside the cabin of the vehicle. The claimants, being legal heirs, claimed compensation against the owner and insurer. of the vehicle number. So, my lord, victim was driver. He was inside the cabin of his vehicle and he was found murdered.
Consider করেছিল
চিন্তা কেন করতে হয় यार?
My lord, Rita Devi not considered the subsequent decision.
Actually, I shall consider. While I was in the deciding claim case in the district court, I came across a decision, same decision. Driver dead in the truck.
Yes.
And a
That is
decision.
Rita Devi. Your lordship will kindly.
No, a decision relied. Decision of Allahabad High Court or Jharkhand High Court, whatever it is.
Bimla Devi, my lord, Bimla Devi.
Yes, death
Yes.
in the use of a motor vehicle.
Yes.
Death occasion in the use of a motor vehicle.
Yes.
163A.
Yes, that is
But
Rita
Milord-
Devi. That is not decided in division bench decision.
But Milord,
My lord,
Rita
page-
Devi.
Rita Devi. Page, my lord.
That decision was so.
My lord is absolutely correct. Milord, nothing with regard to the rash and negligent driving needs to be proved, and it is confined. Milord, 163A schedule is there. It
Yes.
can never exceed 5 lakh. Whichever here, Milord, it is 1 crore.
No, Rita Devi, page
You
22.
take 5 lakh, Milord, I go out of the court. Milord, I will not.
No,
I close
that
my
is not-
brief.
Accident has been happened. Rash and negligent driving is there.
That
Yeah.
driver was found in the vehicle. You say.
Yes.
Not
Milord,
say. Driver was lying inside the vehicle, murdered.
Yes.
So in the use of the vehicle, maximum 5 lakh.
Milord, this.
So 163A was.
Yes.
Your lordship will kindly, Milord, take note of that and use 163A and this. I will not argue.
My lord, I am not the driver.
I go by whatever has fallen.
I am the third party of that vehicle. I am the third party. I was driving my motorcycle.
But now he is not conferring to my lord's view.
No. That is
Because
different.
the question of money.
Yes. Now the question comes. Yes.
This is Deepa Ganguly 166.
Milord, may I continue, Milord?
Yes.
Every second sentence is jumping Deepak Ganguly and Milord Rita. Milord, those have been referred here. Those have
Yes,
been
you read
dealt
out,
with.
Read.
তো না পড়ে কেন তুই চাচাচ্ছিস একবার
বলুন না।
দেখ তারপরে চাচা প্রত্যেক লাইনে আরম্ভ করে দিস
You argue and on the next day come with your written notes and decisions. So if it is 5 lakh, you are agreeable.
Yes, Milord, I give up my case. Your lordship will record and dispose it off here and now.
No.
क्या no?
This is the case of under section
अरे बाकुल तो
166.
जस्ट आपका बात मानो.
Accident has been happened, proved. But rash and negligent driving has been proved.
Okay. Let us see this.
Yes. Who can file under section 163?
ভাই তুই আমার কেসটা তুই বলে দে তাহলে তুই কর আমাকে বলতেই দিবি না কি করে হবে এরকম ভাবে চুপ করে তুই বসে যা না আমাকে বলতে দে আমি 10 মিনিটে শেষ করে দেবো Milord, I was in paragraph 2, the facts were there. Milord, the involvement of vehicle was there. He was found murdered in the cabin. And then on the next day, his body was found. Claim case was filed by the claimant on the similar issue that yes, involvement of vehicle was there. He was the driver of the vehicle. These are admitted facts, Milord. Milord, page number 3. The claimants examined 2 witnesses. FIR, Caesar list, charge sheet, everything was, Milord, filed, exhibited. While disposing of the claim case, tribunal held. In the present case, I'm in paragraph 4, the finding of the tribunal. In the present case, the claimants have claimed that Sheikh Inad Ali was murdered inside the vehicle, number so and so, on National Highway. But the claimants have failed to establish that the death of the Inad Ali was due to rash and negligent driving of the vehicle number this. The tribunal thinks that the claim case is not maintainable and the claimants have no cause of action to file the claim case. It is held that the death of the Inad Ali inside the cabin was not due to rash and negligent driving of the vehicle number. So these issues are disposed of against the claimants. Milord, rash and negligent driving aspect was taken note of because nobody saw that, Milord, rash and negligent driving in this case. Being aggrieved, the claimants preferred this appeal before the Honorable High Court. 6. From the material, it is evident that the post-mortem report shows the cause of death due to effects of strangulation by ligature ante-mortem and homicidal in nature. The case ended in FRT. Investigating officer could not solve or prove the case. Milord, in my case, charge sheet is under 120B and 304A. Criminal conspiracy is there. The claimants have relied upon the following judgments in support of their claim. First one is Rita Devi. Milord, at least 6-7 times he stated the name of Rita Devi. So Rita Devi has been dealt with and taken note of.
No, তারপর Bimla Devi.
তুই বসবি Rita Devi, Milord, the Supreme Court held, Milord, whether it is, Milord, the accident simpliciter or, Milord, it is murder, Milord, that was decided in the case of Rita Devi. Arising out of the use of the vehicle. Milord, that was the question. May I read this Rita Devi's entire reference, or I'll skip it over?
You may read.
Rita Devi, Supreme Court held, the question therefore is, can a murder be an accident in any given case? There is no doubt that murder, as it is understood in the common parlance, is a felonious act where death is caused with intent, and perpetrators of that act normally have a motive against the victim for such killing. But there are also instances where murder can be by accident on a given set of facts. The difference between a murder, which is not an accident, and a murder, which is an accident, depends on the proximity of the cause of such murder. In our opinion, if the dominant intention of the act of felony is to kill any particular person, then such killing is not an accidental murder, but is a murder simpliciter. May I read this line, again? In our opinion, if the dominant intention of the act of felony is to kill any particular person, then such killing is not an accidental murder, but is a murder simpliciter. In our case, the moment it is 120B, what was the dominant intention? They all sat together, they made a plan, and the dominant intention was to kill the murder. Using of the vehicle, only that comes subsequently. Had it not been a vehicle, they would have murdered the person by any other means, because murder was the dominant intention. This is what Rita Devi clarifies. Where, in our opinion, if the dominant intention of the act of felony is to kill any particular person, then such killing is not an accidental murder, but is a murder simpliciter. While if the cause of murder or act of murder was originally not intended, and the same was caused in furtherance of any other felonious act, then such murder is an accidental murder. I go by these wordings, apply. It is not that, on that particular moment, all three of them, those who were sitting in this dumper, they decided that yes, that man is going on the road, let us kill him. No, it was not that. The moment it is 120B, it is a criminal conspiracy. The police says that they had conspired, they had sat together and they decided to kill this person. And the usage of this dumper, it was only a subsequent factor. They could have killed it by the gun, by any other means, by kulhadi or anything. This dumper was only was helping them to kill that person. The act of killing was decided. It was preconceived by way of this conspiracy, which the brother
accused persons,
Lordship,
their defense will be it is an accident.
Yes,
Before the
maybe.
Their defense will always be it is an accident.
We do not have the records of criminal.
First of all, the driver who is involved,
yes,
his defense will be it is an accident.
His defense would be it is an accident. Absolutely.
Vehicle owner, you see, if he is a witness or whatever it is.
Yes.
If he is a charge sheet witness, he will also say yes, it is.
The punishment is lesser.
Whatever it is, yes, say it is an accident.
Yes, definitely,
The
correct.
other conspirators, the moment it is accident, the conspirator will
they go scot-free.
No question of any conspiracy.
No question of any conspiracy.
So, to the conspirators, to this accused person, always it will be an accident. Their defense.
I'm grateful to my lord. I'm grateful to your lordship.
So now let us see the materials.
Paragraph 14. Applying the principles laid down in the above cases to the facts of the case in hand, we find that the deceased, a driver of the auto rickshaw, was duty-bound to have accepted the demand of fare-paying passengers to transport them to the place of their destination. During the course of this duty, if the passengers had decided to commit an act of felony of stealing the auto rickshaw, and in the course of achieving the said object of stealing the auto rickshaw, they had to eliminate the driver of the auto rickshaw, then it cannot be said that the death so caused to the driver of the auto rickshaw was an accidental murder. The stealing of the auto rickshaw was the object of the felony, and the murder that was caused in the said process of stealing the auto rickshaw is only incidental to the act of stealing of the auto rickshaw. Therefore, it has to be said that on the facts and circumstances of this case, the death of the deceased was caused accidentally in the process of committing theft of the auto rickshaw. In the instant case, as we have noticed the fact, we have no hesitation in coming to the conclusion that the murder of the deceased, Dashrath, was due to an accident arising out of the use of the motor vehicle. Therefore, the trial court rightly came to the conclusion that the claimants were entitled for compensation as claimed by them, and the High Court was wrong in coming to the conclusion that death of Dashrath was not caused by an accident involving the use of motor vehicle. Milord, this was the finding of Milord Rita, Supreme Court, Milord, which differentiated Milord between the murder simpliciter and murder, Milord,
accidental.
Milord, thereafter, Milord, another Supreme Court, Oriental versus Milord D. Shakuntala, Milord, this Madras High Court, I'm sorry, Milord. From the above decision, it is obvious that in the present case, the murder of the deceased amounts to an accident arising out of in the use of course of his employment, and so the respondent are entitled to receive the compensation. Where the question is, one, where the cause of death amounted to an accident arising out of in the course of his employment. Two, whether the quantum, we are not interested, Milord. Milord, the answer at 17, internal 17, as per section 3 of the WC Act, undoubtedly the employer is liable to pay compensation in respect of personal injury or death caused to a workman by accident arising out of in the course of employment. Section 4 provides so and so, the way of calculation. Milord, kindly come to page number 6, first sentence. Skip over, the section was quoted. Page number 6, first sentence. The third respondent, owner of the car, has stated that deceased was in receipt of a salary of 1,500. When that is not disputed, the findings of the authority, taking note of all facts, and in arriving, the compensation is found to be reasonable. And 1,500. Here also, the person died during and in course of his employment. That was an admitted fact. So there, it was again taken to be the accidental death.
So far, his death during the discharge of his official duties.
Lordship.
That was the issue.
Yes. So it was
during the discharge of his official duties.
It was considered as an accidental death.
Yes.
This Rita was also considered to be an accidental death. That was not murder simpliciter. I go a step further. I say that no, it was a pre-planned षड्यंत्र, criminal conspiracy, and then the person was killed. Number 9, Deepak Ganguly. Deepak Ganguly, was trying to be taken note of again. And that is 5 times he referred Deepak Ganguly. Deepak Ganguly is also taken note of here.
Yes, the fact is different.
Yes.
Deepak Ganguly's fact and in my case, fact is same.
Yes, let us see this thing.
In our internal paragraph 3, paragraph 9, page 6. In our opinion, the said decision rather supports the case of the appellants. In the case before us, the tribunal, by relying upon the contents of the FIR, pointed out that the victim, as a traffic sergeant, having charged the driver of the taxi concerned under section 184 of the Act for traffic rule violation, sometimes earlier on the same day, the driver, being enraged, knocked the victim down, resulting in his death. If in the process of stealing of an auto rickshaw, a murder of the driver is committed, such death is held to be arising out of the use of the motor vehicle in public place. On the said analogy, killing of a traffic sergeant by the driver of a motor vehicle, being infuriated by the booking of the said very vehicle for the violation of traffic rules earlier on the same day, by running him over with the use of the said vehicle, is on a better footing than the facts leading to the murder in the case of Rita Devi. In this case, the taxi itself is the root of trouble and is also the tool used for killing the victim, while in the case of Rita Devi, the auto rickshaw was the object of felony, but not the instrument used in killing the driver. This Deepak Ganguly is the case of traffic sergeant's killing, or traffic sergeant's accidental death. There was some dispute between this traffic sergeant and a taxi driver.
And he hurriedly.
And taxi driver, then after this dispute, hurriedly ran over this sergeant. Whether this can be considered as a murder simpliciter or not, Honorable Court said that no, it is not a case of murder simpliciter. This, differs from our case, which is a case of षड्यंत्र, and which is a case of criminal conspiracy, wherein more than one person was involved. This Deepak Ganguly, only the driver is there. There is no criminal conspiracy angle. And in my case, I do not say that. Police says so. An independent state authority says so, I have got nothing to do with that. The paragraph, 10, in the present case, deceased was found dead in a vehicle where he was sleeping. The vehicle with the body was found at a different place from the place where it was when the victim went to sleep. The question of theft or attempt to steal the vehicle does not arise as the vehicle with the body of the deceased was found at an isolated spot. No evidence could be gathered during investigation, thus leading to submission of FRT. In the present case, the dominant intention of the act of the felony was to kill the deceased, murdered, like my case. And such a killing was not an accidental murder, but a murder simpliciter. Rita Devi, that is, the reference of Rita Devi was taken. Why it is murder simpliciter? The murder of the deceased was not caused in furtherance of any other felonious act, and as such, the murder in this case was not an accidental murder, but just murder simpliciter. Thus, the claim case in this case is not maintainable, and the appeal of the claimant is dismissed. It was held to be a case of murder simpliciter. Honorable High Court said the tribunal has rightly held it was murder simpliciter and they would not be entitled for any compensation. This has considered Rita Devi, this has considered Deepa Ganguly, and this has considered a lot of other earlier judgments which are on the point of murder, simpliciter, or accidental murder. Milord, insurance company has not made out any new case. Insurance company is simply relying upon the case, Milord, which has been decided or which has been given by the state authorities. The police says the family member of the victim say. If the family member of the victim say, Milord, it was a case of Sodojantro, then that particular member who lost the FIR, he did not come before the court to say that it is not a case of Sodojantro. He said Sodojantro and then Milord, he went away. He did not come forward to negate that. It is their case. It is their family member. It is their FIR. They say Sodojantro. And if I say that you are saying Sodojantro, then they are saying that no. I am bringing another person before the court, and the person who alleged Sodojantro, my family, I will not bring him to the court. Why? If you allege, forget about what I can. What they have done, I am showing that to you.
You are.
Okay, what is the relevant portion? Deepa Ganguly?
There, yes. Even if it is intentional, then also, my lord. Paragraph 13 onwards.
My lord, the award of the tribunal starts at page. Deepa Ganguly judgment. My lord is referring to the judgment, my lord, of Deepa Ganguly?
Yes.
Relevant portion.
13 onwards, my lord. Your lordships will find. Even if it intentional, then also, my lord, accident has been happened. And the victim was on the road. He was driving his motorcycle. From backside, my lord, the truck dashed the victim vehicle from backside.
আমি আমার কোনো কেস তৈরি করছি না, আমি তোমার কেসটাই বলছি জোরসে, যেটা তুমি বলছো, তোমার বাড়ির লোক, তোমার পুলিশ,
আপনি তো টানতে
ওরা বলছে মার্ডার হচ্ছে,
না,
আমি
মার্ডার বলেনি, বলেছে থাকতে পারে।
না তো পুলিশ বলেছে তো ক্রিমিনাল কনস্পিরেসি আছে, আমি বলছি
ক্রিমিনাল
তো তোমার,
পুলিশ আমার কেন, পুলিশ
তোমার থেকে পয়সা নিয়েছে তোমার,
পাবলিক সার্ভেন্ট।
তাহলে পুলিশের কথাটাও শুনবে না?
না,
না,
আমার তো অ্যাক্সিডেন্ট হয়েছে।
আরে মানে বললে হবে? অ্যাক্সিডেন্ট হয়েছে, পুলিশের কথা শুনবে না? পুলিশের এফআইআর মানবে, পুলিশ বলেছে গাড়ি মেরেছে সেটা মানবে,
পুলিশ বলেছে যে
পুলিশ বলছে ষড়যন্ত্র সেটা মানবে না।
পুলিশ বলেছে যে পুলিশ বলেছে পুলিশ বলেছে যে ওখানে ড্রাইভিং হয়েছে,
সেটা গাড়ি থেকে মেরেছে, গাড়ি থেকে
কি বলছে? হ্যাঁ,
Now, the question is with regard to quantum.
Quantum, my lord.
This is one ground of challenge.
This is one ground of challenge, my lord. Quantum, my lord, there is no dispute with regard to quantum. Only thing your lordship will kindly come, my lord.
Quantum, what is taken into consideration?
My lord, page number, my lord, the yearly income has been taken on the basis of ITR. I am not disputing that. Absolutely correct. My lord, your lordship will kindly come to page number 29 of this award, of this paper book, my lord. Page 29.
এটা দেখিয়ে দেবেন এখানে আছে
কোনটা?
pay and recovery. My lord,
হ্যাঁ,
page
হ্যাঁ,
30, bottom portion, your lordship will find.
29.
एक सेकंड टोकता है ना यार मैं बोलने नहीं देता. Your lordship will my lord is there page 29. My lord, the chart is there in the middle. Your lordship sees item 7 heads. My lord, the chart in the middle.
Yes, yes, yes.
Item 7, my lord, loss of consortium. It is 1,20,000. 40,000 into 3. My lord, it should be 40,000. The children should not get. My lord, this is the only reduction that I was praying for. Other heads, my lord, absolutely okay. No trouble to your lordship with regard to that. And my lord, this right to recover.
That is already given.
That is already given. Your lordship will kindly.
Page 30.
My lord, your lordship will kindly, my lord, if my lord is concluding the hearing.
You want to continue further?
My lord, no, my lord, I'm asking, my lord. That is why I want to finish it off, my lord.
So finish it.
So my lord.
10 minutes is there.
Yes.
My lord, this is
So,
regarding
my lord, if my lord, in case I am unable to convince your lordship, my lord, if I convince my lord, then I win hands down, my lord. I get my money back. But if I am unable to convince your lordship, my lord, then your lordship will kindly, my lord, make one note in the order sheet that the right to recover remains unaltered. My lord, otherwise, my lord, again I will face trouble, my lord, with right to recovery. In case if I lose, my lord, and if I succeed, my lord, I would be extremely grateful to my lord. And this, my lord, 80,000, my lord, should be reduced from the total compensation amount. And I have deposited entire money with interest before.
6% interest is
Yes,
awarded.
with my lord. So, my lord, if they succeed, my lord, your lordship will ask my lord's officer to calculate less 80,000 with 6% interest, disburse it to them, balance should be given to me, and my right to recover remains unaltered. Your lordship will kindly make a note, otherwise your lordship, my lord, with a lot of, my lord.
regarding my lord consortium, I have referred to recent decisions.
Consortium নিয়ে অনেক কথা হয়ে গেছে, আধ ঘন্টা consortium নিয়ে হয়েছে।
দুটো judgment দিয়ে দিয়েছি জজ সাহেবকে। Latest decisions of this
Which
2026.
Which over and above the plenary city.
Then let me do one thing. Let me refer this matter to the division bench to decide this consortium matter.
Lordship.
So 80,000 be decided by the division bench.
Lordship.
That I can do today itself.
My lord, that part, my lord, the wife and 2 children has been suffering.
My lord, he is
Have you
getting
considered that?
80 lakhs. The problem is 80,000. This is what I said. My lord's view was beneficial legislation. Let something be given to them, and with 80 lakhs, one is not happy. Then, my lord, what further beneficial legislation, my lord? In this case, how come it comes into the picture?
Kindly consider that, my lord, because my lord,
And in any event, my lord is not granting, my lord, this consortium to the children, my lord. In any event, that is Rajesh Rajvi.
And the amount of compensation is 80 lakh.
My lord, 54 lakh is in principle. My lord,
54 lakh
in principle. My lord, I have
1,973.
Yes.
I have already deposited 66 lakhs before my lord.
So if 80 lakh goes,
80,000.
Sorry, 80,000 goes.
It doesn't make any difference. It is not even 1%.
Yes. That is 53,000 something.
Yes.
90,000 or something like that.
Yes, my lord.
So, my lord, what difference does it make?
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing of the case is concluded. Let this matter appear for judgment on 17/3/2026. I'll fix another date, okay? Because I've already fixed matters at 3 p.m. then 2 p.m. another matter. So it's better I'll fix another date.
চেষ্টা করব পড়তে পারেন এটা চেষ্টা করি যদি হয়ে যায়
No. Okay, I shall fix it. Let it appear tomorrow as to be mentioned, or today I shall fix a date.
I'm not extremely grateful to your lordship for bearing up with me, my lord. Obliged, my lord.
under competence after with regard to item number 24 for submission of written notes of argument.
Item
Tomorrow I will
number
not be there, my lord.
24.
Difficulties, my lord, I will not come.
Item number 24. Who is appearing?
Hearing has already been concluded. Right? I am for the.
Let it appear as to be mentioned
My lord, I have also
on Monday.
Monday, my lord, Monday I will not be available, my lord.
Let
As
it
per
appear
my
to be mentioned on Thursday.
Thursday.
Okay. In the presence of the other side, you can file your written notes of arguments. Other side has filed written notes of arguments.
No, my lord, that matter was fixed on 4 p.m. on Monday due to, my lord, the one member, one honorable judge expired. That's why this court will rise.
So save and accept filing written notes of arguments.
Yes.
Nothing is left.
Nothing.
So better I am keeping it on Thursday. It will appear as to be mentioned. Intimate the other side.
Yes.
May I permitted to mention one matter? On 23rd February, your lordship passed an order. There are some typographical errors. Only I am praying let it appear as to be mentioned or for correction.
Anyway, give it.
And tomorrow or
$1 million, I am for the one.
A big paper on me of the appeal list.
Yes. Hence, application CAN 3 of 2025 stands disposed. The defendants appellants are permitted to keep the bamboo and wooden articles in the suit plot which is lying at present, subject to the deposit of costs of rupees 10,000 before the Registrar General High Court, Calcutta. Stop. In the event the appeal succeeds, the defendants appellants will be permitted to withdraw the security deposit. In the event the appeal fails, the plaintiffs will get the security deposit and articles in the suit plot will have to be removed. The learned special officer stands discharged. Let a final remuneration of 100 GM be paid to the learned special officer by the respondents. Yes, costs to be deposited within 10 days.
Lordship, within a fortnight, Lordship.
Okay, within 2 weeks.
Obliged.
So, special officer is discharged. Please clear the remuneration.
Obliged.
Milord, this appeal of claimant, Milord, can be disposed of. Milord, we have worked out together.
So this is your appeal.
Milord, this is claimant's
My
appeal.
appeal,
Milord,
I am appealing for the appellant.
Milord, in order
What is the ground of appeal?
Milord, it's an injury case. May I just, Milord,
Yes.
Milord, assist your lordship, Milord. It's an injury case. Milord, on the basis of monthly income of rupees 8, it's a Milord case of amputation. On the basis of monthly income of rupees 8,000 per month, Milord, an award of
5,98,000.
नहीं हमारा calculation टा कौन था
11,96,000.
11,96,000 Milord was principal awarded, Milord. Milord, it was Milord, the victim was the driver himself. He was driving a truck. He collided with another truck. So, Milord, for contributory negligence, Milord, police filed charge sheet against the victim and against the other driver, Milord. For contributory negligence, Milord, 50% was deducted. And Milord, the principal sum of Milord, 5,98,000, 6 lakh. Milord was awarded. Out of 11,96,000, 12 lakh, Milord. 6,000 was awarded to him. Milord, my learned friend today on behalf of claimant, Milord, he has come up. Milord, 2-3 points are, Milord, missing in the award passed by the tribunal. Milord, future prospect was not granted. He says, okay, fine, 50% I was responsible, okay, let it be deducted. But since future prospect was not granted, give me future prospect. Milord, interest, Milord, for a certain period, for the COVID period was not granted. He says, Milord, give me the interest for that. And disablement, Milord, was assessed at the rate of 70%. Milord, learned tribunal just said that, no, I will not give the loss of funding capacity 70%, I'll give it 60%. Milord, he wants that 70% to be given. loss of earning capacity. My lord, I agree to that, my lord. Amputation case, my lord, I have made a calculation, I have shown it to my lord, and he agrees to that. If my lord can dispose of, my lord, the appeal, my lord, on the basis of this calculation, my lord, without recording our consent, my lord, but we agree to this, my lord. This appeal can be disposed
Or
of.
give some just and reasonable compensation
grateful to your
as a
lordship.
whole.
As a whole, my lord, I'm grateful to your lordship. This is a total calculation which my lord would be passing the order.
So the learned trial judge granted pain and suffering 1 lakh, loss of future income 8 lakh 6,400.
Yes, 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 yes.
Medical expense 1 lakh 75,000.
My lord, in my calculation, your lordship will kindly see, my lord.
Yes.
The same.
Page 9 of the award. That's right, page 9 of the award. Running page 9.
Yes, my lord, is that page 120 of the paper book? I can just indicate to your lordship.
Page 10 of the operative portion. Yes, where is the paper book? Paper book to the next.
Page
file
100. Page 100 and okay, internal page देखो ना.
My lord, page 120 of the paper book, if your lordship kindly comes to.
120. अच्छा ठीक है.
Yes.
My lord, at the top, my lord will kindly see, my lord, the different heads are given A, B, C, D, E.
Yes.
Determination of claim. My lord, A remains same. B increases, my lord. B I have given in my calculation. C, D, E, everything else remains same in my calculation, not in my handwritten calculation. Every figure is there.
96,025. Okay, 25% future prospect
Yes,
1 lakh
it was not
20,000.
granted by the tribunal, my lord. They are entitled.
और जैसा कि वो B का calculation has not been shown in the award. He was arrived.
If any particular query, my lord intends to make.
So for monthly income, okay, annual income,
Yes.
25%, that is 24,000.
Yes, it was
So
not
should
granted.
be,
I have given.
should be on the basis of 1 lakh 20,000, 70%.
Yes.
But the tribunal has
given 60%.
60%.
Lordship.
So 3 grounds: the future prospect,
yes,
the 70% disability,
yes,
and the multiplier is like
Same mind.
and the third is with
my lord, I'll just indicate to your lordship, my lord, kindly come to page 121 of this paper book, my lord. First paragraph. Page 121, first paragraph, last sentence, starting from however. However, insurance company is exempted from paying interest for the COVID period. Not they should get that. Not amputation case. Not this interest they should get. And on the enhanced amount, not 6% from the date of filing. Not enhanced amount I have shown to your lordship in my lord's calculation. Enhanced
1,84,800.
I will
at best it can go to 2 lakh.
My lord will make it, my lord.
Okay.
My lord, this 184 or whatever my lord decides.
6% from the date of filing
plus interest for this COVID period, which was not given to them. So
anyway,
this appeal can be disposed
6%. So total claim they should be entitled is 11,96,400. That is 50%.
Yes. That they had got 5,98,200. They have received that.
They will get interest.
I have shown my lord in my calculation the last
5,98,200.
They have received principal amount with interest.
On this, they will get the interest for COVID period only.
So on this, the earlier sum awarded, additional this sum, 6% interest from the date of filing till today, excluding the sum which is already deposited, including interest, be adjusted.
Yes. Yes. So my lord will today, my lord, will make the calculation. Your lordship has got my calculation sheet.
Yes.
My lord, total calculation.
1,84,000, very well, 2 lakh.
Or my lord, otherwise, your lordship say their total entitlement is 7,83,000. My lord, this is the total calculation.
Yes.
Out of this, whatever they have, this they will get from my lord with 6% interest. 783 they are entitled to. Out of this, whatever they have received, minus that, whatever.
No, 7,83,000.
Yes.
Probably it was It was their entitlement. 7 lakh.
It is their entitlement.
It is their entitlement.
It is. So, my lord, out of 783, it is their entitlement, total entitlement as of now. Out of this 783, whatever I have paid, whatever interest I have paid, my lord, your lordship will ask me to deduct that, adjust that, and pay the balance.
That is 1,84,000.
1,84,000.
800.
800 principal, and with 6%, and say in addition to that 6% of that COVID period interest, that also they should get. I'm just trying to make my lord's task a little easier.
No, shall I suppose net amount which they are to get is, as per calculation, is 1,84,800
Yes,
net amount.
additional amount.
So, to this, if I make it 2 lakh,
Lordship.
so
Or not 7,83,000, your lordship will make it 8 lakh.
8 lakhs.
8 lakh. Make it simple.
Yes, yes. 8 lakh and then
Whatever they have received, less
5,98,000.
They have received 5,98,200. My lord, the way my lord is passing the order, my lord says their total entitlement is 8 lakh. Out of this 8 lakh, whatever they have received, let that be adjusted. Balance amount to be deposited by insurance company with 6. My lord, they are entitled 8 lakh with 6% from the date of filing till the date of payment.
Right.
Out of this, whatever they have received, let that be adjusted. Balance amount insurance company to deposit. Just to simplify the whole thing.
Pushkar. That means it comes to about 2,01,800.
Yes. I won't dispute that. Your lordship will kindly record one line. Claimants admit that they have received the amount awarded by the tribunal. Just one line. Your lordship will kindly add that.
Yes, record an order.
I'm grateful to my lordship. Extremely obliged, your lordship.
Learned advocates for the parties are present. Hard learned advocates for the parties. The appellant before this court was a claimant in a case under Section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 20th day of August 2024 passed by learned Additional District Judge, Third Court, Krishnanagar, Nodia, in MAC case number 139 of 2016. Stop. The case of the claimants before the learned trial court may be summed up thus. On 26/6/2014, the claimant was going towards 26/6.
Not 23rd June.
As per the claim petition, it is 26/6.
Not the award of tribunal says 23rd June.
23rd June নয়, এটা হচ্ছে 28th
Tribunal
August.
award, my lord, page 110.
It is illegible.
Page 110, the very first sentence.
Yes, it is illegible.
Judgment 19th day of August 2020.
जो तरीके accident जब सब
Accident না, accident হচ্ছে এটা বলছি।
It's illegible.
Continue with that, Lord, in case of correction, I'll indicate your option.
Continue with 26/6.
Continue with 23/6, my lord.
Okay, 23. But you see, in the petition it is stated. Anyway, from the FIR and all this thing, it is
I'll
corroborated.
check it up. Which correction is
On
second?
23/6/2014, the claimant was going towards Kolani, driving lorry number WB25 capital C stroke 4976 by the left side of NH 34 at Tatigachi in front of the house of Subroto Sarkar. Stop. Another lorry being number WB25 capital D stroke 9100 came from Kolkata with high and excessive speed in negligently and going towards Chagda came to its extreme right side, dashed against lorry number WB25C stroke 4976. As a result, driver of the said lorry number WB25C stroke 4976 sustained serious injuries on his person and leg. Stop. Seeing the said accident, local people took the claimant victim to Ranaghat SD hospital, admitted him there, and thereafter the claimant was referred to Kolkata. But the claimant was admitted at Bhattacharjee Orthopedics and Related Research Center P Limited at Narayanpur and discharged on 23/7/2014. Stop. Due to high speed, rash and negligent driving of lorry number 25 capital D stroke 9100, the accident took place. Stop. The petitioner is now 70% disabled person and is unable to do work. Pursuant to filing of this case, notice was issued upon the opposite parties. Stop. Opposite party vehicle owner did not contest the case. Stop. However, the opposite party appellant Cholamandalam MS General Insurance Company, opposite party respondent number 1, Cholamandalam MS General Insurance Company Limited, contested the case by filing written statement. Stop. Issues were framed and evidence was adduced.
Yes.
Stop. Upon hearing the learned advocates and considering the evidence, the learned trial judge was pleased to dispose of the claim case by observing and directing as follows. Page 120. ঠিক আছে? এখানে এটা folded করে দেওয়া হচ্ছে. Stop. The claimant appellant, being aggrieved by the quantum of compensation awarded by the learned trial judge, has come up with the instant appeal. Stop. Heard learned advocate for the appellant claimants and learned advocate for the insurance company respondent number 1. Peruse the materials on record. Learned advocate for the claimant appellant submits that the learned trial judge erred in not considering the future prospect while assessing the compensation. Stop. It is further submitted that the learned trial judge ought to have assessed the disability more than the disability which the learned judge has assessed. Stop. It is also submitted that the learned judge ought to have awarded interest from the date of filing of the claim case till the date of realization, but the COVID period interest is excluded. Mr. Singh, learned counsel for the respondent number 1, disputes the submission of the learned advocate for the appellant. Upon hearing the learned advocates and considering the facts of the case, this court is of the view that considering the nature of the injury, period of stay in the hospital, and the percentage of disability suffered, the quantum of compensation should be enhanced. Thus, the compensation should be as follows. Monthly income 8,000. The annual income comes to rupees 96,000. 25% future prospect, if taken into consideration, the total monthly income comes to rupees 1,20,000.
Annual income.
Total annual income comes to rupees 1,20,000. Stop. 70% disability brings the quantum to rupees 84,000. The multiplier of 14 is to be applied, and the loss of income due to disability is rupees 11,76,000. Further, on account of pain and suffering, this court is of the view that the claimant should get rupees 1 lakh, medical expenses 1,75,000, rupees 1 lakh, medical expense rupees 1,75,000, attendant rupees 15,000, and loss due to disability and disfigurement rupees 1 lakh. Thus, the total cost on account of the accident, total compensation on account of accident comes to rupees 15,66,000. Stop. As there was contributory negligence on the part of the petitioner, the compensation comes to rupees 7,83,000 by arithmetical calculation. However, this court is of the view that rupees 8 lakh compensation is just and reasonable. Stop. Thus, the claimant appellant is entitled to compensation of rupees 8 lakh from the respondent number 1 insurance company along with interest at the rate of 6% per annum from the date of filing of the claim case till today. The appellant insurance company shall deposit the awarded sum, deposit the compensation amount along with interest within period of 8 weeks from the date of communication. Deposit the compensation amount within period of 8 weeks from the date of communication of this order. Stop. In the event the amount directed by the learned trial court is already paid or deposited, the balance amount shall be deposited. The appellant claimant is entitled to withdraw the sum deposited upon compliance of the necessary formalities.
One indulgence,
Yes.
there is a can.
Okay, is there any pay and recovery in this matter?
No, no.
Oh.
There is a can, there was a delay. Lots of kindly.
169 days delay.
আচ্ছা সকলের আগে একটা করে দেবেন, হ্যাঁ? The application for condonation of delay is taken up for consideration upon hearing the learned advocates. This court is of the view that the delay should be condoned. Thus, I condone the delay in preferring this appeal. তারপরে ওইটা সবার উপরে এটা দিয়ে দেবেন।
Informal paper book already filed.
This is okay. Okay.
Seven.
Yes.
Me plus. The matter, earlier occasions, matter was heard by your lordships, and regarding the earlier occasions, you had heard the matter. Regarding the both the orders are illegal. Both the court below is wrong, and the order passed by the both the court below is wrong. In the suit for partition, your lordship knows the suit for partition, and partition suit the learned trial court decided the deed of gift in a suit. In connection of the suit of partition suit, when a deed of gift has been decided in a two form, one partition suit, one.
Okay, you are coming against the order of the first appellate court.
My lord. Both the orders is conform with the order passed by the trial.
So both the court helps against you.
My lord.
Okay, what are the substantial questions of law which this court is to consider at present, on which this appeal is to be heard of?
My lord. The question, the question law, the suit is, actually the suit has been filed among themselves, but those other co-servers has not been made party. My entire, my lord, that is the only point. That is the only point. Your lordship can see page 2 of the paper book. Your lordship can page 200 dag number, several dags. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 20, 15 dags is there.
Yes.
My lord, can you see? 2181, 2182, 2180, my lord, page on second paragraph. My lord, you see 20125, 2012, 2010, subsequently, my lord, several dags is there. But they are the suit for my lord, partition regarding the several dags. But there are no other co-sharer is there. Only among the three persons, one of the partition suit has been filed. They are not the actual, they are the actual owner of the in respect of all the property.
No, no.
Other co-sharer, Yajmani property.
No, no. You are
Man,
the
line
plaintiff.
is trial court will hold.
You are the plaintiff in the trial court.
My lord.
Okay.
My lord.
So you have filed the suit in pleading.
No. But I am for the, my lord, dependent. I am the dependent.
You are coming against preliminary decree.
My lord. But this is only the degree, my lord, I am the dependent. I am a preliminary degree, but the preliminary degree may not be passed by the trial court. But I am the defendant in this of the suit. Original suit. And their suit for partition. They challenge they are praying for, the only deed in question. They are saying the deed is void.
Now let us
Only, can you see the observation of the trial court? Can you see?
Page.
Can you see? I'm coming, my lord. I'm sorry, my lord, I'm coming. They're only taking point, yes, void the plaintiffs on page 51. Page 51 of the paper book. The plaintiffs and the defendants to get a preliminary degree for partition. When you got it? Page 51? 51. The plaintiffs and defendants do get a degree for partition. It is declared that the plaintiff number 1 and 2 jointly have 1/7 share. The plaintiff number 3 and 4 jointly have 1/7 share. And each of the defendant number 1, 5 have share 1/7 share of the alert plot 2181, 2182, 2391, 2393. But this is the 1, 2, 3, 4 dag is there. 2181, 2182, 2392, and 2393 of Mauja Dakara PS Balurghat, specially described in the schedule Kh of the plaintiff. This deed of gift, especially described in the schedule Kh of the plaintiff, are declared as void, invalid, and not binding upon the plaintiffs. This is the case. My lord, the deed only the partition suit.
No, deed of gift specifically described in schedule Kh. It is declared by the plaintiff. So the schedule is by the plaintiff, prepared by the plaintiff.
But the deed of gift.
Yes, you see, by virtue of deed of gifts, somebody has acquired the property.
My lord.
That is what is
our property.
That is what the plaintiffs have stated.
And we obtain the deed of gift. We obtain the deed of gift.
That is the plaintiff's case. You see, the deed of gift specifically described in schedule Kh of the plaintiff. That means whatever is stated in schedule Kh of the plaintiff, that is the plaintiff's case.
My lord.
So it is the plaintiff's case.
My lord. Or deed is void.
The plaintiff has not sought any declaration that is void.
My lord. They are prayer. The original deed, which has been gifted to me, my father. My father gifted the deed.
No. Did the plaintiff seek any declaration with regard to the nullity of that gift?
Why? This suit for partition?
Yes.
But this suit for partition? This suit for partition? But this is suit for partition? But this suit for partition? The entire property should be partitioned by the trial court. But other co-sharer is there. Can you see the record of rights? For a moment, your lords, can you see the record of rights? And can you see separate? There are several co-sharers is there. Different co-sharers. How the 7 persons or 4 persons, 6 persons are coming and paying for partition of deed, partition of the suit property? They are entitled. The suit is maintainable. This suit absolutely bad, illegal, and this should be set aside. And can you see?
So regarding suit for declaration and partition.
Partition and declaration. My lord, this is a suit for partition and for declaration that the deed being number such and such 1, 2, 3, 4, and 5, 6. one, two, three deeds are invalid. 3 gift deed, my lord. We have obtained the gift deed from my father. My lord, they are not looking after the father. They are outside, they are residing outside. We are the 3 brothers. My lord, they are maintaining my father, and my father, according to his own will, and according to his own will, and my lord, his according to his own choice, he will not gifted the property to the defendant by virtue of 3 deeds. Now, my plaintiff is coming, other sharer is coming, brother.
What is your relation, brother?
Brother. My absolute brother, my lord. Now, my lord, there is a brother. Other co-sharers are there. My lord, the property big rahot. My father's name is Sudhir Chandra. My father's name is Sudhir Chandra Mandal. My lord, he died on 27/11/2008. According to the plaintiff, one of the son of Sudhir Chandra Mandal, namely, I'll see for a moment, page 2, I'm sorry, my lord, page 2, your lordship, I'm not disturbing your lordship, because your lordship knows me, I like to remove this. Sudhir Chandra Mandal, namely Sushil Chandra Mandal, predecessors Sudhir Chandra Mandal and the plaintiff number 1 and 2 are the legal heirs of Sudhir Chandra Mandal. There are no legal heirs. After death of Sudhir Chandra Mandal, there are several, my lord, the co-sharers.
That is a factual aspect, okay.
No, that suit is not maintainable.
No, question is, what is the proposition of law on which this matter is to be the
How he decided, how the court below decided the
validity of the gift,
my lord,
by which the appellants claim to be the absolute owner of the part. Then,
my lord,
that part of the property claimed to have been given.
Well, 3 gifts are registered on 2011-2003. More fully described in civil court, the plaintiffs have stated that they came to know about the deed of gift on 15. How he came to know? When they obtained the certified copy of those deeds, the plaintiffs has, page 3, the plaintiffs has specially stated that Sudhir Chandra Mandal never gifted these properties voluntarily, my lord, to the defendant. And the deeds of gifts are forged, fraudulent, illegal, and not acted upon. Their version. The plaintiffs have further stated that Sudhir Chandra Mandal, my father, my lord, was a literate person, but the deeds bears LTI of the execution. They have further stated that in all those deeds on Prabir Kumar Datta was identified, or LTI of execution by Prabir Kumar Datta was known as Sudhir Chandra Mandal. They have further stated that Sudhir Chandra Mandal never expressed his intention to transfer property in favor of any persons. Rather, he used to possess the suit property till the last breath. The plaintiffs have further stated that the deeds are not executed voluntarily, and Sudhir Chandra Mandal was not in the proper physical and mental state to execute the deeds. It is further case of the plaintiff that the plaintiffs are entitled to get 2/7 share of the suit properties, as the suit properties have not been partitioned by meets and bounds amongst the co-sharer. Among the co-sharer, one can mind it. One can say among the co-sharer, who are the co-sharer? We are not the actual co-sharer, only co-sharer. There are other co-sharers there. Everybody property is there. For a moment, you will also kindly see how they are saying among the co-sharer. Can you see for a moment? On page 4, I am saying, you will also kindly see page 4, bound among the co-sharer. Partition maybe meets and bounds among the co-sharer. I have no objection. We have no objection. If the partition has been done in respect to all the properties, in respect to suit properties, I have no objection. You will also direction may be given to the trial court. Remand back this matter to the trial court for first trial by immediate party. Those who are the co-sharer, regional property. I have no objection. I have no objection. I am not going to the merits. I am not going to law in question. You will also return back this.
Question is, we have to
hear. But this is absolutely
hear,
my lord.
This second appeal on these questions,
my lord,
regarding error committed by adjudging the validity of the gift.
How 1/7 CR? Only they are saying 1/7 CR. How 1/7 CR? There are several. You will also the record of rights. Can you for a moment? The Porcha record of rights.
Page 3.
No, the record of rights have given record of Porcha. Record of rights I'm given.
Part of the paper book.
No, my lord, these
not
are
exhibited.
My lord, exhibit no. My lord,
no. Then how can I look into those?
My lord, the record of rights are
They are not part of the.
No. If it is not exhibited, it cannot be looked into.
Yes.
at this stage.
They prepared the
All- all-
paper book. They prepared the paper book.
No.
They did not understand any
Nothing
document
you
there.
see, you cannot.
Now they are raising new.
Now,
books
whatever
and
is
new
there
books
in the paper book, in the
one
record,
after another.
That is true. That is true. You know, that,
whatever is there in the record, that will be.
Permitted to
I'm sorry,
point
that
out
is true.
basic questions, my lord.
Anyway, you just argue on the, you see, judgment
My
Yes.
of both the courts.
My lord. There are several example property. I will say for a moment. Now I'm coming to your lordship. Your lordship, kindly see the observation of the trial court. My kindly see. My kindly see the observation of the trial court. But I'm coming, Lord. I'm sorry, Lord, the observation of the trial court. I'm coming. When I did in question, without the question only without the signature of the attested witnesses. There are differences there. They are saying that the page 21. Page 21 of paper book. For a moment. You also can see page 21. Paper book. I've got it with also. The observation of the trial court. Page 21.
My lord,
But this is the observation of trial court. For a moment. Page
my lord,
21.
allow me to.
No, let him conclude. Thereafter, you will be allowed.
আপনি বলবেন তো, আমি দেখে দিচ্ছি জজ সাহেব, কোনো অসুবিধা নেই। মাইনর কাইন্ডলি পেজ 21 kindly see for a moment. Page 21. In instant case, these observations of the trial court. In the instant case, admittedly, one attesting witnesses signed in this deed, exhibit C, D, and E, and there is no other attesting witnesses who signed in this deed. The scribe Satyapriyo Lohasi signed as a deed writer, and there is no endorsement in the deed that he signed as a attesting witnesses. So it is futile exercise on part of the defendant.
No, let me see. One attesting witness signing the deeds.
My lord, deed to one witnesses. But as per evidence act, two witnesses required. But as per regarding party, transfer property act. But when you also the parties, section 68 of the evidence act, man can see for a moment. Man can move on.
No, how many witnesses were there in the deed?
One witness.
One witness as identified witness.
Admitted.
It was drafted by whom it was there.
My lord. And he signed this as witness 62 mark corona. 62 mark can see 62 for a moment. Man for a moment. I am sorry, my lord. 168. And 68 can see the evidence. One witness is required. Like learned trial court observe. One can see. Learned advocate for the defendants also tried to convince that as per the section 68 of Evidence Act, only one attesting witness is to be called for. 68 you also can see. Regarding deed in question. Only when arguing in respect of deed in question.
No, let us come to the this is in order to prove the execution of a gift deed, okay?
My lord.
You have to examine at least one attesting witness.
My
if you want to prove the
that's what evidence act.
You see, the execution of gift deed is not disputed. Okay,
my lord.
That is challenged to set it, to strike it down, to declare it bad in law.
In the partition suit.
You come to transfer of property act. How many witnesses are
two
there?
Witnesses required.
Yes,
two witnesses required.
So,
my lord, my lord, 123 of transfer property as per section 123 transfer property act. Two attested witnesses are required to make a valid deed of gift, and the requirement of section 68, my lord, of Indian Evidence Act is quite different from section 123 transfer of property act. Section 68 of the Indian Evidence Act comes into play the time of proof, execution of documents required of law to attested, and in that case, the testimony of one attesting witnesses is sufficient. Man, can you see for a moment, page 22? Page 22 for a moment. Page 22 for a moment. Man, I'm sorry, my lord, I will not disturbing your lordship.
Yes.
One witnesses, man, can you see for a moment? Section 68 of the Indian Evidence Act comes into play, and to time to prove execution of the documents required by law to attesting, and in that case, the testimony of one witness, attesting witnesses, is sufficient for proving the execution of the deed. But it is not mean that a deed of gift can be validity made and the attesting one witnesses. So, after considering all these facts, I am of the firm opinion that as the alleged deed and are not valid in the eye of law because there's absolutely illegal observation of the trial court. They are made mandatory provisions of law for making a valid deed of gift. The claim of defendant that the defendant number 1, 3, and 4 become the owner of the properties mentioned in the deed C, D, and F is not sustainable in law because the deed are not valid. So the fact remains, for a moment, I'm sorry, I'm disturbing your lordship. The fact remains, the properties of Sri Chandra Mandal will be developed upon his legal heirs. Mind it, these legal heirs, which entirely at the alleged deeds cannot be devoid any properties. As discussed above, the alleged deeds cannot confirm any title of deed hold properties in suit plots in the defendant 1, 3, and 4. And accordingly, they are not binding upon the parties. So the properties left to Sri Chandra Mandal will be inherited by the parties as per law of succession. Law of succession. So, my lord, the deed is Esmali property. My joint property, Miss Joint property, page 24.
If the gift goes, then your right with it on the basis of that gift does not remain. But if the gift is sustained, if the gift is not proved to be bad in law, then you have a case.
That is true.
So the thing is this, whether the
It's
gift
very clear.
is
But regarding my lord, the page 24, the joint Miss Joint parties, page 24. Can I see for a moment? Page 24. But this will be deleted. Miss section 24, you also see. But so far as the plot, and I'm sorry, my lord, page 24. But so far as the plot number 2039, 2005, 2010, 2016, these are one of gift party. 2025, 2033 are concerned. It appears from the documents, Exhibit 1, Series and A, to that there are other co-sharers. Your lordship kindly got it? There are other co-sharers there. There are other co-sharers in this plot. We are not the absolute owner. My client also, and I also, we are not exclusive owners. We are not the owner. We are not the exclusive owner. Only exclusive. But there are other co-sharers. These observations of trial court. How we, only gift, it will be decided by the gift. Maybe gift is void or invalid, genuine or not valid or invalid. I'm not going to that. But regarding the suit in question, absolutely illegal. This is only my submission. My observation of trial court, have not but implemented. Your lordship, I see, but the plaintiff have not implemented. Can you got it, my lord?
Yes.
Implemented. Them, those who are the co-sharers, you also mind it. Though they have knowledge about these persons, without knowledge, they have not made party. Having knowledge, because they have not made party in the suit. Can I see for a moment, next minute? It is settled principles of law, can I see, that in case of a partition, suit all the persons having interested, can you got it, over the suit property must be implicated in the suit for partition. This is the case. This is my only case. Forget about what I did. Maybe suit is void. Maybe suit is not genuine. But the suit is absolutely bad. Why is it?
Non-gender of necessary parties.
Yes. Yes. Other co-sharers, many co-sharers is there. We are not the owner. My London client not the owner. We are not the owner. Absolute owner. But there are the other co-sharers. Already Sri Chandra Das Mandal, there's big riot. He has, my lord, various plot is there. Huge property is there. Huge co-sharer is there. For that reason, trial court will observe. Can see the term necessary parties means those persons whose presence is indispensable for suit, and in their absence, can you got it? No effective degree can be passed. You also got it?
Yes.
No effective degree can be passed by the court. This degree is void, absolutely void, illegal. This order should be set aside. Generally, misjoinder, next line, can see. Generally, misjoinder and non-joinder parties is not fatal for the suit, but the court should defer from passing a degree which would be ineffective and infructuous. You will have to kindly see the inability of the court to pass an effective degree when all parties in the subject matter the suit are not present before me, it may due either the nature of the action of nature, interest that person who has no subject matter of the suit. But it also ought to be mentioned, this is a partition suit, the property in respect of partition among the co-sharer. Where is the other law, other degree, other deed in question, void, invalid, that is the question. Impedance, I know, can see. It also ought to mention here that who has the burden in a partition suit to impede all the persons. Who has the burden? The individual has got burden. The individual will add the party. You'll also direct the court, trial court, to rehear the matter by remand back. You'll also remand back this matter to trial court. You'll also send back the matter to trial court for further hearing, further determination by impeding as a party of the co-sharer, other co-sharer. Who are the co-sharer? Where are they? They should be deprived. Only 6 persons will get the property, their property. My 3 persons, my 3 brothers, by virtue of deed, gift, and therefore my landlord's clients will not 4 co-sharers. But they will get.
That means your share will also reduce if there are more co-sharers.
Yes, maybe reduce. Maybe you'll also, maybe reduce. You'll also, entire property will be.
But there will be prevention of the multiplicity of litigation.
Yes, yes. Everybody will get. Every co-sharer will get their own share. This is my own argument. This is my first argument. Every co-sharer is there. There are several co-sharers there. For the court will not observe the partition suit to impede all the persons having interested in the suit property and they answer the plaintiff. The plaintiff is the person who files the suit and he has the duty. One can see last line, page 24. Page 24, last line. Plaintiff's duty. Last line, page 24. Last line. The plaintiff is the person who files the suit and he has the duty or the burden of impeded all the interested parties. But the burden is here, plaintiff's burden. Man can see burden to impede all the interested persons in the suit of partition. The suit partition, several co-sharers are there. Why they will be deprived? My share will be deducted. I have no objection. And the reason is all persons having interested in the suit property are the co-sharers to the suit property. This partition suit, not for declaration suit. The deed will be decided by the declaration suit. If the deed is void or invalid, valid or invalid, right or wrong, but this will not be decided in the suit. Why deed should be decided in the suit? Why? How? How is it legal, illegal, valid, invalid? Why? Why trial court decided this deed? Why? This is my only question. If the suit is bad, mutual parties, other parties are there lying in the street. They are living in the street, but they have a right in the property. Plaintiffs have a right. Plaintiffs have the duty. They have to pay party in the suit. Like observation of the trial court. But how trial court pass such an order? This order should be right. Well, here and now. One can see suit property are the co-sharer to the suit property, and in their absence, one can see in their absence, adjudication of the suit cannot be made effectively.
Yes, which paragraph are you reading?
Page 25. Page 25. I am not arguing with your lordship. This is my last argument. You also can see page 25. Page 25. Man, can you see? Can you see for a moment? Other co-sharers, they are living in the street. They should be deprived by this way. By this way. We are the 3 brothers. They are the 3 brothers. Other sisters is there. Siddhar's sons is there. Puthi Chandra Mondo died 2008. There are several co-sharers there. The trial court right to observe. But at the time of passing of the order, she allowed the suit. How? It is astonished. How are 177 there? Other shareholder is there. Is money property. One can see for a moment, and adjudication of the case cannot be made effectively. From the documents, plaintiffs, exhibit number 1, it appears there. There are other possessors. One can see for the second line, page 25, you also can got it. Page 25, page 25. Page 25. One can see the one. I'm sorry, Milord, I'm distracting your lordship. I'm sorry, Milord. It appears that there are other possessor, co-sharer in respect to the plot. Got it, my lord? Page 25. other co-sharer, other possessor in respect of the suit plot, like in plot number such and such, several ducts, the name of Sudhir Chandra Mandal. He is the original owner. He died 2008. My grandfather, our grandfather, our father, but the co-sharer's grandfather, our father, co-sharer's grandfather, the Calcutta, that is Calcutta, we are the father of the, we are the son of the father, Sudhir Chandra Mandal. Now, it appears there are possessors, and there are other co-sharers, namely Gautam Mandal. Can see the name? Gautam Mandal, Narayan Chandra Mandal. Where are they? Where is there? Who are there? Narayan Chandra Mandal, Bipul Chandra Mandal. Got it? Manoranjan Mandal. Your Lordship got it? Similarly, for plot number such and such, the name of the Sudhir Chandra Mandal stands for 3 decimals, and there are other co-sharers. Your Lordship got it?
Yes.
My Lord. Namely, Niranjan Mandal. My Lord got it? Bela Mandal, Bela Mahanto. Where is there? Gola Mahanto. Manik Mandal, Mahanto. Accordingly, apart from the parties to the suit, there are co-sharers to the suit plot number such and such, such and such. The plaintiffs cannot avoid, cannot evade their responsibilities. My Lord, can you see? Their responsibilities. This is not my responsibilities. They are trying to grab the property, entire property. Entire property, they are trying to grab the property. I am telling you, Lordships. They are trying to grab the entire property by this way, by this partition suit. How partition suit? Why partition suit? 30 members is there, 30 persons is there, 40 persons are there, 47, they are possessing also. You also got it earlier, okay? Possessor and co-sharers, one can see. They are the, appears there, they are the other possessor and co-sharer. How partition suit will be affected? By 6 persons? My Lord, learned client 3 persons? Or 3 brothers, 6 brothers. Suppose 7 brothers, 7 persons, your Lord, you knows. How it will be divided? How it will be divided? How it will be co-sharer? How it will be partitioned? Deed is void. Deed is void. Yes, I admit, deed is void. But why partition suit? Allowed. This suit, you will remain by this matter, here and now. You will not remain by this matter before the trial court, and he heard the matter after hearing the emptying in the party. Plaintiff is directed to empty the party co-sharer and passing necessary order. I have no objection. I have no objection. I have no objection. Man, can you see? It has the suit for partition should be dismissed on the ground of defect of man, can you see for a moment. Responsibilities towards adding necessary parties. I got it? Middle portion. Page 25.
No, one issue is dismissed on the ground of non-joinder.
Yes, yes.
But one issue is decided against you. That is
yes, that is correct. That is correct.
issue is decided against you.
That is deed.
That is also upheld by the appeal court.
That is in the question of deed question.
Yes, if that is decided against you, that is a res judicata with regard to issue. Now, when it goes back to the trial court,
yes,
that is binding.
My Lord.
So if you accept that,
yes, your Lordship, that is
no. If you accept that, then you have to proceed that all are this thing.
My Lord, the latter trial court will decide.
Now let us see the appeal court's judgment.
My Lord. My Lord, your Lordship, my Lord, for a moment, your Lordship, I am sorry, my Lord. This suit, it is tried law that the suit is petition should not be dismissed. My Lord, can you see? Fail to necessary parties. Step against.
Anyway, continue on the next day. 3:30 is that today.
What, my Lord?
Today is we have to rise at 3:30.
My Lord.
So continue on the next day.
Yes.
My Lord, actually, the division bench of this honorable court identified only 3 questions.
Yes.
Only 3 questions, substantial questions. That's what.
Let us hear the appeal court's judgment.
That is the question of.
Yes, your Lordship, I shall appeal court judgment. Appeal court, question order. Appeal court, my Lord.
We shall go argue on the first appellate court judgment.
Okay. Appeal court order, my Lord, by confirm the order with trial court. Nothing else.
No,
confirm, not confirm.
Already send back the matter for modification of the order, man. That's the order.
Hence, the other case appeal fails. That is the appeal court order.
That is why
before pending.
trial court's order, but the appellate court order already.
Yes,
sent back.
maybe
So
that appeal court already,
After that, this second
appeal court
appeal
that
filed.
also holds that on that point, the deed is void.
the question is, if the appeal court's order is upheld, that
No.
means that means on the basis of the parties before the trial court,
Yes,
okay, the suit has to be adjudicated.
yes,
That's why the
yes.
Two things, trial court also held against your learned friend one issue with regard to the gift.
Gift in
all
question.
the,
And
That is
the-
correct.
all these
and
Correct.
the appeal court,
that is identified by the first appellate court.
yes,
already.
okay, that
All these
that
fault
issue.
already identified by the appellate court already.
So both there is a concurrent findings that the gift is bad, okay, by the appeal court.
Exactly.
Now this is to be
Our question
now this is to be considered by this court,
by
that with regard to the gift matter,
gift matter.
and now with
That is-
regard to the non-joinder of parties.
Yes.
Only that the substantial
Malakasi,
questions were decided by the
Ejmali
division bench.
property. You also can see however, the parties to the suit have Ejmali rights. And can you see the observation of the trial court? Ejmali rights.
It's ordered, my lord.
Over those plots being the legal heirs of Sri Chandra Mandal. This is Ejmali property. There
Yes, whether the decree passed by learned court below is perverse or not.
my lord, this is perverse. The order is bad. Yes, that is you are also correct.
Not declaring the appellants as the owner of the
My lord.
paper. Anyway, mainly that gift.
Mainly gift. Mainly gift is decided in the partition suit. Appeal court also, trial court also. In the partition suit, my lord, deed has been decided.
Yes, record an order.
This is my only submission.
Learned
Decided.
advocates for the
My lord,
parties
get full
are
order.
present.
Get full orders. I'm sorry, my lord, get full orders.
Acha. So you have concluded your part, or do you want to on the hard learned advocates? Let this matter appear for further hearing. দেখুন তো কবে ইয়ে আছে?
My lord, as part of my lord, you can see, observe. Already is there, my lord, I think, my lord, part of it. Next one, appeal court order. Appeal court, same findings.
Okay. 31/3/2026 at 3 p.m.
My lord, get full orders. 20 mile 26.
31/3/2026 at 3 p.m.
31.
Yes.
Get full orders.
Come tomorrow.